Good morning, everybody. Welcome to the Courtroom Files live on a Friday, which just so happens to be Halloween. I'm Michael Groff, filling in for Dan Soley yet again today and all next week as well. And it's a spooky edition of the Courtroom Files live. Be sure to hang around. Lots of fun stuff coming up. But first, we'll start our day in Michigan with who else but Judge Simpson
versus Erica Ward and Aaron Ward.
Good morning, Your Honor. Zach Revolt on behalf of the plaintiff.
And are the wards here? They are. Okay, good morning. All right, what is plaintiff's claim in this case?
Yeah, Your Honor. So plaintiff is seeking a possession judgment against the defendants related to breaches of a commercial lease between the parties. Ultimately, plaintiffs are just seeking a trial date to get a possession judgment that can be executed as soon as possible.
All right. I don't know, counsel, if you received a number of different documents filed by, I think you folks are represented by Donna Tobe.
Yes, Erica and Aaron Ward, the tenants.
So, counsel, did you receive those?
We did, Your Honor, but we did not receive them actually until like Wednesday evening around 5 p.m. So very late.
Yes. And so, I mean, there have been some answers, but I'm not sure why she filed an ex parte motion to adjourn. I think they would be entitled to an adjournment for a week in any event. So what I'm going to do is I'm going to put this out 1 week, not granting her motion because I don't think it was proper to be filed as an ex parte motion. But there is an answer to the complaint, which it seems to me in reviewing it has potential counterclaims and a request to suspend the plaintiff's eviction action. So we need to deal with all of that, but I guess we'll have to wait till next week to do so. So what I will do is I'll adjourn these proceedings, folks, to November 7th, 2025. That's at 1 p.m. Folks, that is a in-person proceeding, so everybody will need to be at the courthouse.
And
Okay.
Your Honor, if I may, would you like my client representative in person as well?
Normally I would say that counsel can, for the plaintiff, can represent it, but it would likely be fruitful if there was a representative, given what I see in the documents file.
Understood. Thank you.
All right. Thank you, folks.
Thank you, Your Honor.
Thanks, Your Honor.
Court does call the case. Maple Heights Apartments versus Jeffrey, is it Payette?
Yes, sir, it's Payette.
I'm sorry, say that again, sir. You muffled there.
I said, yes, it's Payette.
Okay, got you. You're still muffled, but I got you. All right.
And good morning,
Maple
Your Honor.
Heights.
Yeah, good morning, Your Honor. Sean Mock for the plaintiff.
All right. And what is plaintiff's claim in this case?
Yeah, this is an action for non-payment of rent seeking possession only. The rent to retain through the month of October is $1,650. Court cost of $170.05. So the total amount my client's seeking right now through October is $1,820.05. Payment last made on this file, $500 payment made September 30th, 2025.
All right. Sir,
Yes,
how are you intending on getting this paid?
I could pay it all off that payment that they talked about this month and next month's rent, November's rent, all in November. I just need the payment plan. That's all. I could, but
I'm
My
okay.
job-
Hold on. You're muffled again. I don't know what's wrong with your mic. I can kind of make out kind of what you're saying. You said you can have it all, including next month. When do you think you can have that?
before November ends, I have all of that before the month of November ends. What to have me in December, which I would be on track then.
Gotcha. Okay, so here's what I'm gonna do. you're entitled to an adjournment, so I'm going to adjourn this matter out to November 7th, 2025. What at 1 p.m. That's an in-person proceeding, so everybody would need to be at the courthouse. But what I would suggest you do, sir, is contact the plaintiff's counsel and see what you can work out in terms of a payment. Sounds to me like you've got a plan in place. See if that'll work for them.
Okay, thank you.
Thank you, Your
All
Honor.
right. Thank you. Court does call the case of Mill Pond Manor versus, is it Changming Pond?
Yes, Your Honor.
Good morning. Good morning, Your Honor. James Martone appearing on behalf of the plaintiff.
Good morning, Your Honor. Student Attorney Calvin O'Connell, joined by my partner Allison Futter and our supervisor Sarah Sallin from the University of Michigan Civil Criminal Law Clinic on behalf of our client, Mr.
Boy,
Fan.
that's a long intro. Go.
Apologies, Your Honor, but
Go on.
there is more.
There's more? Okay,
I know.
go for it. I got all morning.
We are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Ms. Sallin.
Have you been before me?
I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really damp there. It's like rain, just rain. It's just, I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
Oh, is that different? That's different than UW.
No, that is UW, Your Honor.
Is it? They're in Seattle?
Yes, North Seattle.
You understand that they beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here in Michigan now. That's where my league.
You didn't belong in the game. Listen, anyway, I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Ms. Sullivan. Yeah.
Good morning, Judge.
All right. What are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a lease, a residential lease agreement. We're seeking, basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive answer and affirmative defenses from defendants, as well as a demand for a jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move for summary disposition in this case on the basis of what we believe are multiple park forest violations. Attached to our motion are exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow. All of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. And I will note just briefly for the court that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor, if I
Yes, go ahead.
if I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
if I may, Judge.
Yeah, go ahead.
We have been engaged with Mr. Phan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we have been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Phan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Phan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Phan was led to believe that acceptance of rent or other actions waive that termination of tenancy notice. In fact, I
think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no. Is it possible to? Do you need an answer date or a hearing date?
Yeah. Well, I just need. How much time are you going to need to file an answer, and then I can give you a hearing date.
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday. December 2nd.
That's my next day.
I'm sorry,
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and then we'll see whether we go forward.
Thank you, Your Honor. Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Phan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate.
My short answer would be no, but you have it,
I do. That was filed as a general civil matter.
so it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing is gone forward on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over because it doesn't make sense to, I don't know what the issues are in that filing. But it would seem to me that if they relate to the tenancy, it would be best that it be handled in one place. So
And it looks like
I will talk to Judge Barr about that, and then we'll deal with it on the 18th.
Thank you, Your Honor. I appreciate it.
All right. Okay. Thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
We'll try. Thank you, Your Honor.
All right. Good morning again, everybody. Welcome to the Courtroom Files Live. It's a Friday, a spooky edition of the Courtroom Files Live. It is, after all, Halloween, where anything can happen. Now, of course, Fridays often mean landlord-tenant cases, and, normally we kind of steer clear of some of that around here. Although if anybody can make landlord-tenant interesting, it's Judge Simpson, and that's why we do sometimes see what's going on over there. We had a very interesting landlord-tenant the other day there. I believe that was like a 3-parter. So if you missed that, you can go back and watch the live show from the other day. All right, let's switch it up. Judge Elmore has a sentencing going on right now. So we'll head on over there as we do kind of the Michigan 2-step here and see what's going on
Maureen McDade, then.
with Judge Elmore.
All right. So we're next going to take up the case of People of the State of Michigan versus Corinne McDade. File number is 25-14134FH. Appearances, please.
Barnes on behalf of the people. And I'm Jeff Harrison. I'm here on behalf of Ms. McDade. She's joining me at the table. You see it to my left.
Thank you. We're here today for a pretrial conference and court-ordered meeting between the parties, the court, to determine what's going to happen with this case. As I've been told by the parties that we intend to enter a pretrial agreement. Mr. Carnes, why don't you go ahead and tell me the terms of that agreement, sir?
Yes, Your Honor.
It's my understanding that defendant will plead guilty to an added count of attempted possession of a taser. There is also a kill-or-brew agreement to a 6-month delay of sentence with a full dismissal. If the defendant is successful on the delay, success would mean compliance with any probation terms that the court may incorporate.
All right, Mr. Harrison, is that a complete and accurate statement of the pretrial agreement?
It is indeed. Thank you
All
for
right.
covering all the moving parts, Mr. Carter.
Thank you. You may, thank you. Ms. McDade, is that how you resolve today's case?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
You may lower your hand. Ms. McDade, looking back on May 12th of this year, were you on probation, parole, or bond?
No.
And currently you are charged with a single count of possession or sale of a taser, or a portable device that emits an electrical current. That is a felony punishable by up to 4 years and or up to $2,000, plus mandatory forfeiture of the weapon or device. I'm told you're going to enter a plea to an added count 2, which would be an attempted possession of a taser. Now, an attempted possession of a taser would be would be a misdemeanor, for which you could be punished by no more than 2 years in prison or no more than 1 year in jail. Now, the difference is minor, but it would be basically no more than 1 year in jail. But what I'm told is if you enter that plea, the prosecutor agrees to a killer brew. A killer brew is an agreement between you and the prosecutor that says there's some agreement with the sentence. And then if we come to the sentencing and I don't go along with that term, you would have the right to withdraw your plea. Now, the agreement is that you would be placed upon a period of a delay. A delay has terms or conditions that are similar to probation, but it's not technically probation. The differences don't really matter a whole lot to you, other than you would have to comply with the terms or conditions that would be similar to probation. And then if you complete that 6 months without violating any of those terms or conditions, the charge would be dismissed. Is that what you understood?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm the information? You swear or affirm the information testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes, Your Honor.
You do that. It's one of those days. Thank you. Go ahead, lower your hand. By entering a plea of guilty, you'll be given up certain rights and not have a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses presented against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent during the trial, the right to not have a silence used against you, and the right to testify if you chose to testify. Do you understand those rights?
Yes, Your Honor.
And more importantly, do you understand that if you plead guilty and I accept that plea, you will be forever waiving those rights as they apply to only this case?
Yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal, not an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told me today on the record. Have there been any other promises, threats, or inducements you haven't told me about?
No, Your Honor.
Do you still wish to enter? I'm sorry, has anybody made any promises to you as to exactly what this would do for sentencing?
No, Your Honor.
Knowing that, do you still wish to enter the plea as we discussed?
Yes, Your Honor.
As added count 2, attempted possession of a taser, a misdemeanor. How do you plead?
Guilty, Your Honor.
Before the court can accept that plea, I need you to tell me what you did that makes you guilty of the offense. Turning your attention back to that date on May 12th of 2025 in Liberty Township in Wexford County. How were you caught with this device?
I had purchased this weapon and had placed it in my car a few weeks prior to being pulled over. I had gotten pulled over coming home, and they did a search on my car and had found that, and I had forgot to take it out of my car.
And you ever tested the device?
No.
And do we know what kind of device it was?
It was just a small, like, handheld, like, stun gun. I had purchased it on a cheap website.
Do I have a photograph? I'm going to tell you, the taser possession charges are always annoying.
Yeah.
All right, they're often very silly, because I guarantee you nobody on that side of the courtroom has tested it, and the police never tested it, or they've never told me how many volts are in it. Yes, sir.
Your Honor, if Mr. Harrison will stipulate to this, I did speak with Trooper West.
Okay.
And he did test it.
He did?
He did.
Oh.
There was an arc.
Good.
There was an arc and a crackling noise, and he was satisfied. I spoke to the trooper as well.
All right, then I'll accept,
In anticipation of that issue.
I'll accept that. I'm glad they're starting to do that, because we've had trials where people have shown up and the police have shown up with the taser and it wouldn't kill a fly. And we've had to throw the case out because they're silly, right? Because sometimes people buy something thinking it'll do something, but it doesn't actually do it. That's why they sell them. All right. Mr. Carnes, you believe you provided a factual basis?
Yes, Your Honor.
Are you aware of any other promises, threats, inducements?
No, Your Honor.
Do the court's compliance with court rules?
Yes, Your Honor.
Mr. Harrison, do you agree?
I do.
The court agrees and finds the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record, as well as the agreement between the parties as a stipulation as to workability of this object. The defendant is found guilty to added count 2. Count 1 will be dismissed at the time of sentencing. Between now and sentencing, which will be in about 4 weeks from this coming Monday, an agent from the Department of Corrections is going to prepare a pre-sentence investigation report. That report will describe the offense, the pretrial agreement, statements or information about you, information about any prior criminal history you may or may not have, and also make a recommendation as a sentence. Please keep in mind it is merely a recommendation, as it is the court alone determines the sentence. When you leave this courtroom, you're going to go to the elevator, take the elevator all the way down to the bottom floor, step out to a button hook to the right, and there's a door. Do you know where the probation office is?
No, Your Honor.
Okay, so anyways, when you turn around, you start walking down a little ramp, you'll see a mural of, in black and white, of World War I soldiers. Keep walking straight. Of course, stop when you get to the door and don't walk into it. Open it, go inside that hallway. Second door on the left. Second door on the left. If you have any questions, ask anyone in that hallway and say, listen, I just was told by the judge to come down here. And if you say my name, all they'll do is send you to the right window. Okay?
Thank you.
All right. Any questions?
No.
Thank you very much. Bond continues. We are hereby adjourned.
All right, everybody, welcome to the Courtroom Files Live. It is a Friday, a Freya Friday. The cat right now is hanging around, kind of bouncing back and forth between the studio and the other room, so maybe she'll be joining us. That's what's going on in Judge Elmore's court. Let's head down to, we'll probably go back there, by the way. Let's head down to Florida because it's Jackson County, but this is normally where you'd see Wade Mercer or Judge Garcia, but instead they've hot swapped out a judge from Washington County. This looks like it is somebody by the name of Judge Peel. So let's see what's going on.
Yes, Your Honor, we can.
In Florida.
Very well. I'm Judge Peel from over in Washington County. I have with me on the screen this morning Ms. Ford from the State Attorney's Office, Mr. Bigelow from the Public Defender's Office. We have 3 for first appearance in Jackson County. Mr. Bigelow, I'll appoint you to represent each of those 3 individuals. Officer, have they already seen the video regarding their first appearance rights?
Yes, Your Honor, they have.
All right, Mr. Bigelow, if you'd like to give them any additional advice before I get started, you're welcome to do so at this time.
Good morning. This is First Appearances. I'd like to remind you that everything we're doing this morning is being recorded. Anything that you say can be used to issue proceedings. The judge may ask some questions, where you work, that sort of thing. I advise you to answer those questions, but do not go into the details of the particular case. Also, be cautious what you say on the phones there at the jail. Those phones are recorded. Thank you.
Thank you, Mr. Bigelow. We'll start with Ronald Ray Edinburgh. Mr. Edinburgh, if I could get you to step forward for me, please, sir. Edinburgh, good morning. You had an opportunity to watch the video regarding your first appearance rights. You heard the advice that Mr. Bigelow gave. Do you have any questions about your rights this morning?
No, sir.
Mr. Edinburgh, you're charged with battery on first offense. That's a misdemeanor. It's punishable by a maximum penalty of 11 months, 29 days in the county jail. I've reviewed the affidavit and complaint, find there's probable cause for the charge. Mr. Edinburgh, it's also my understanding that you were out on bond for a battery involving the same victim. Judge Mercer has already done an order revoking your bond in case 25507MM. I have reviewed this file. I see that you live in Jackson County. I'm not going to ask you any additional questions this morning because you're going to be held without bond anyway. I will set you a bond on the new battery charge in the amount of $5,000, order you to have no contact with Catherine Clark. But again, it wouldn't do you any good to post that bond because I'm ordering that you be held without bond in case 25507MM. They'll get you back up in front of Judge Mercer on his next arraignment date. Do you have any questions this morning?
No, sir.
All right. Thank you, sir. Ladarian Brown. Brown, good morning. You had an opportunity to watch the video regarding first appearance rights. You heard the advice Mr. Bigelow gave. Do you have any questions about your rights?
No, sir.
Sir, you're here on a driving while license suspended or revoked as a habitual offender. That's a 3rd-degree felony. It carries a maximum penalty of 5 years in prison. Mr. Brown, do you live in Jackson County?
Yes, sir.
Are you working anywhere currently?
Yes, sir.
What type of work do you do?
Environmental services.
Brown, are you currently on state probation or county probation?
No, sir.
All right, and I didn't find anything, and I looked at your criminal history. I'm going to set you a $5,000 bond this morning and order you not to drive or operate a motor vehicle. So make sure if you get out of jail and you post that bond that you're not driving unless and until you get a valid driver's license, okay?
Any
sir.
questions?
This is my second time, I guess being arrested for the same thing. How could it, okay, for the first time me being pulled over, was getting arrested for a FR suspension. So,
Yep,
how could I fix that?
Well, you can talk to your public defender about that, or go to the Department of Highway Safety and Motor Vehicles and find out what's the issue and why your license are suspended. You get them back before court, that might help you. I don't know. If you're able to get a valid license, sometimes it does. Okay?
Yes, sir.
All right, good luck to you, sir. Tramel Jaquez Holmes. Mr. Holmes, good morning. You had an opportunity to watch the video regarding first appearance rights. You heard the advice that Mr. Bigelow gave. Do you have any questions about your rights this morning?
No, sir.
All right, you're here on two warrants. One is a violation of state probation, case 23-311. Looks like you were on for fleeing and eluding a law enforcement officer. They've alleged that you violated your state probation by committing new crimes of possession of a controlled substance and resisting an officer without violence. Based on that, Judge Garcia has signed a warrant. She's ordered that you be held without bond. You also have a warrant for the charges that I just listed, and that's possession of a controlled substance, MDMA, and resisting an officer without violence. The possession of a controlled substance is a third-degree felony, carries up to 5 years in prison. The resisting charge in this case is a misdemeanor, carries a maximum penalty of 11 months, 29 days in jail. I see that you live in Mariana. Are you working anywhere currently?
Yes, I was.
What type of work were you doing?
I was working at the peanut mill.
Okay. And I've reviewed your history and I'm aware that you're on state probation. You're entitled to a bond on the new charge, the new warrant in case 25-386 CF. I'll set you a bond, $5,000 on the possession of a controlled substance, $2,500 on the resisting without violence. I'll order a special condition of that bond that you be subject to a random urinalysis. I anticipate that's already a condition of your probation anyway. So on the new charge, it's $7,500 with a random UA. And on the 23-311, which is a violation of state probation, it's a hold without bond. They'll get you back up in front of Judge Garcia on her next arraignment date. Do you have any questions this morning?
No, sir.
All right, good luck to you, sir. Officer, does that take care of everyone in Jackson County this morning?
Yes, Your Honor, it does.
Any questions about anything we've done?
No, Your Honor.
All right, thank you so much. You all have a nice day.
All right. Well, that was a very fast round of first appearances down in Jackson County, Florida, with a substitute judge, just like I am the substitute host here. Michael Groff filling in for Dan Soul this week and next week. And normally there's a game night on Saturday night here on TCF, unless I can somehow figure out how to stream me playing games, which if you thought that a balding man in his 50s playing video games was thrilling content, wait till you watch a blind guy in his late 40s playing video games. That is really exciting content. Maybe we'll do that. But anyway, I'll be here all next week as well. That's good news if you like it, bad news if you don't. All right, we'll head down to Texas. Let's say good morning to Judge Stevens.
My apologies.
Looks like there's a motion to revoke going on down here.
Yes, yes.
All right. Okay, in 15-22031, the state of Texas versus Aaron Police Green, there was a motion to revoke probation that had been filed in July of this year, which has one ground of an issue, and that is that the defendant is in arrears, and it shows $35,000 in arrears as of June 9th. That must be for assessed fees total. Restitution was ordered in the amount of $30,000, and apparently not very much has been paid toward that in 10 years, correct?
Correct.
So what are we going to do? The victims are entitled to be reimbursed. That's how we fix problems. This was an arson, correct?
Yes.
Where damage was done, I guess, to the owner's building, the building's owner, financially.
Yeah.
So what are we doing about it?
Erase on the
I mean, this is a. I mean, the defendant is looking at up to 10 years in prison. But in 10 years, literally nothing has been paid toward restitution. Everything's going to other fees, correct?
No, sir. It was amended in 2021 for the payments to go to restitution.
So, okay, since 2021, how much has gone to restitution total?
Well, total, there's been $3,434.
Okay. All right. So, Ms. Green, and right now we're just looking at whatever she pays goes directly to restitution. Correct, everybody? All right. How much are you able to pay a month toward restitution?
What I've been paying, monthly, except for these last couple of months, it's been $100 a month.
Okay. And is that the most you're able to pay, 100 a month?
Yes.
Everything else goes to other necessary expenses?
Yes.
All right. Anybody want to ask this lady something?
I don't want to ask
The
her.
state is curious about anything we want to ask to get more restitution here?
No, sir.
Have you talked to her about any other options that are available? She's on a fixed income of some sort.
Yeah.
What is your fixed income, ma'am?
Well, I'm not working. I haven't been able to get a job with my background.
What is your fixed income right now? How much you get in income?
Only thing I receive is food stamps. My husband is working and has been providing for me. And we've been working, he's worked from paycheck to paycheck, and he does the best that he can.
What does he do for a living?
He works with Amazon, with driving the trucks in the yard of Amazon.
Okay, and what is his income? Do you know?
Well, I should know that, but it's about 15 a week.
Okay. So that's about $40,000.
You're talking about in a year.
Yes, in a year.
Give it take, yes.
And again, your income, you say all you receive are food stamps? You don't receive any other type of income?
No, nothing.
Okay. From probation, anything you know about that?
No, sir, she does not. I'm not sure why, because there's some mental health issues. I'm not sure why she's not receiving Social Security.
You don't receive Social Security or any other type of governmental subsistence?
I got denied. I went as far as my doctor and everything with that, and I got denied because they did x-rays of my back and my knee. Physically, I've been having troubles with my thyroid and getting my weight off. It's been, I barely can walk sometimes. My legs get so swollen.
Okay. All right. Well, anything anybody wants to add about this? I don't see any evidence in the record that shows she can pay more than she's paying.
Right. She's been paying $100 consecutively since January of 20.
Well, that's, we'll just
And she doesn't have any other violations of any kind.
Yeah, $100 only gets you back 1,200 a year. So we can do the math. We're looking at 20 plus years.
Any other violations, no positives, she was reporting.
The victims have to get paid back. So anything else anybody wants to add? It all goes back to, it's all going to restitution now. She's on an inactive type.
They
probation.
returned her case when she turned herself in and her case expired. They said that they would be willing to take it back if we wanted to send the courtesy supervision back to Tarrant County.
Correct. What do you think we should do?
I don't know that. I don't know
If
what's.
restitution is, it goes to Tarrant County, she's still gonna have to pay restitution, right?
Right.
So. Do you live in Tarrant County?
Yes.
That's one. What? Which one is the most cost effective for Jefferson County? That's who I represent. I mean, why are we bringing it back down here? Let them do it, right? Let them handle it where she is. That's more convenient for everybody, isn't it?
For her to report to them.
Yeah, and then pay through that
Here.
and monthly, and that's what I think.
She sends her payments to us.
She sends directly to you?
Mhm.
Well, there's no reason she needs to be coming here.
Yes.
I don't think she does not come here, and I don't think
So
that's possible
we'll
for
just
her to come here.
maintain the status quo. She can report to Tarrant County, but those payments must be made at least $100 per month, ma'am. Do you understand, Ms. Green?
Yes.
We'll review it, what, in a year?
I suppose, Judge.
I guess that's what we'll do. Okay, we'll review it in a year because otherwise nothing is materially changed in this situation. All right, good luck. And we'll see you back in a year unless you somehow win the lottery.
No. I can hope, sir, because if there's any way, I would like to repay those people every penny.
Well, that's what's right. I mean, I know that's what you want, but that's what's right, but it's got to be done. So we'll do the best we can. Okay.
Yes. Thank you so much, sir.
Yes, ma'am. Okay. Anything else, Ms. Minaldi or State?
No, sir.
No. Okay. We're in recess on that case. Gavin, Bond. And that's Mr. Shalander. Are we ready on Mr. Shalander?
He's getting the defendant to sign off at back right now, sir.
Aaron, you can log off. We're done for today.
Yep. Thank you, ma'am.
Thank you.
Okay, thank you.
It's the Courtroom Files Live, or the Courtroom Lyles 5 here on Halloween. It's very scary out there. We had a case a little while ago in Judge Elmore's court regarding a taser possession, someone illegally possessing a taser, which caused some stir in the chat. Pretty dumb law. I guess you have to have a permit to carry a taser in Michigan. Some states, you can't have a taser at all, yet you can have a gun, which is very strange to be able to have a firearm, but not a taser. Arizona, by the way, where we're based here at TCF, it doesn't matter. You can have a gun, you can have a taser, you can have a tank, you can have a nuclear weapon if you want. That's just how we roll here in Arizona. That's just the way it should be, America. Yeah. Anyway, back to Judge Stevens.
No, that's, yeah, that would be ridiculous. That is, I can't imagine that victims are not considered in that county, but they ought to be, but that, maybe they misunderstood, but who in the right mind is going to say, yeah, I work for the people and I am not interested in their receiving restitution, the victims being dealt with. We could have done something to help them, but we don't. That's not right. That doesn't make sense.
I've never encountered that before. And she basically came out and said to me, well, you can't revoke her for money. And I said, I can stop her case from expiring. Yes, I can do that. I mean, her go before her judge. But she had to it was kind of weird. I've never had that before, though.
They're not Jefferson County. That's for sure.
Right. It kind of felt like maybe she had told Aaron that too. Like we could remote her for money. It felt weird.
Do you care if I go up and knock on the
She's been very nice to us. Eric. She very well. She says she applied for the job, so you can't drive a car. So
I don't know he's got it. I'm just like scared. Well, I don't know.
I mean, we have one case Mr. Schalander is working on for disposition on a plea, and that's going to be Gavin Bond, correct? Gavin Bond, 2 cases.
We're supposed to go on. I don't think we can be online for a juvenile.
Was that what this is?
Yes, he's a juvenile. Anyway,
Wait, hold on.
he's certified as an adult. Is it both cases, Daniel?
Yes, ma'am.
Okay.
There was also a dismissal on there, Your Honor, for appointment.
I'm charging with.
Okay.
One if I can. It's big.
How old are you, sir, right now? Your age?
16.
Okay. Right. We're going to be going dark on this since it involves someone younger than 17 years of age. And we will be going dark on this hearing since it involves a defendant younger than 17 years of age.
Oh.
I'm gonna be.
Well, I guess Judge Stevens is going to go silent on this one. And so with that, since it's involving a minor, we will shift over to, let's see, where do we want to go? We've got, we still have landlord tenant going over here in Judge Simpson's court, but it sure looks like Judge Elmore has another sentencing coming up. So maybe we can shift back over there and see what's going on in Judge Elmore's court. Maybe we lost audio there. We sure did. All right. It's Halloween. That's what happens sometimes on Halloween. We lose audio, but it's okay. I can certainly vamp. I am a professional broadcaster after all. Just been doing this forever. So what do I know? Let's see if I can get you that audio because we wanted to go back to Judge Elmore. Let me put this back here. And I'll tell you what, the ghosts and the goblins, they had stayed away this morning from the equipment. But today they're coming out now. So we'll have to take that up with them. All right, I think we got this now. I think we're good. We put this here, and there you go. Just like that. Boom, Judge Elmore, and another sentencing.
Thank you. Thank you. You said Mr. Childers?
Yeah.
All right. We're going to next take up the case of People of the State of Michigan versus Zachary Childers. File number is 25-14137 FH. Is he here in the courtroom?
He is.
All right, come on forward, sir. Use that half door. Appearances from counsel.
Jake Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Childers. He's now joined me at the table and standing to my right.
Thank you. You may be seated. Today for a pre-trial conference. Off the record, parties have informed me that they have reached and may have reached a pre-trial agreement resolving the case. Mr. Carnes, why don't you go ahead and tell me what's going on?
Yes, Your Honor. It's my understanding that Mr. Childers is going to plead guilty to count 1, carrying a concealed weapon, as well as an added count of firearms brandishing. The people will be dismissing count 2, felonious assault, And there is a Killebrew agreement here to sentencing under HIDA.
That comports with my understanding as well, Your Honor.
All right.
And Your Honor, if I may approach, we need a written version of that.
Brandishing, is it a 90 or 93 day? It seems like it's a 90
I
day.
think it's a 90-day, Your Honor. I do
90
have the
days.
statute listed on here, but I didn't do my
All right,
homework.
thanks. All right, I'll take a look. I think it's 90. All right, Mr. Childers, is that how you wish to resolve the case today, sir?
Yes, sir.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
You may lower your hand. It's 90 days and $100, not 500. All right, Mr. Childers, make sure everything you tell me today is the truth. I'm going to believe that it is. Don't come back and try to change the story. All right, after today. Looking back on October 3rd of this year, were you on probation, bond, or parole?
No, sir.
You are currently charged in a piece of paper with 2 counts. Count 1 is possession, or sorry, carrying a concealed weapon. The allegation here is that it was a pistol and you were carrying it and transporting it in a vehicle, specifically a Chevrolet Camaro. That is a felony punishable by up to 5 years and or up to $2,500 plus mandatory forfeiture of the weapon or device. I'm told you're going to plead guilty to that count. Count 2 is assault with a dangerous weapon, also known as felonious assault. That is a felony punishable by up to 4 years and or up to $2,000 in fines and costs. I'm told that that count will be dismissed. I'm told that you will plead to an added count 3 of brandishing a firearm in public, and that is a misdemeanor punishable by up to 90 days and or up to $100 in fines and costs. Do you understand?
Yes, sir.
So is that what you intend to plead to?
Yes, Your Honor.
Okay. Now, by pleading guilty, if I accept that plea, we'll be waiving certain rights as they apply to this case. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question or cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent at the trial, the right to not have that silence used against you, and the right to testify if you're to testify at the trial. Do you understand those rights?
Yes, sir.
And even more importantly, do you understand that if you plead guilty, as we discussed, and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes, Your Honor.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right, which is only allowed when you're convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You also will be given up the right to claim the plea was a result of any promise, threat, or inducement not told to me today on the court. I'm sorry, on the record. Have there been any other promises, threats, or inducements that we haven't discussed?
No, sir.
Are you entering the plea of your own free choice?
Yes, sir.
Now, Mr. Harrison's probably talked to you about the Michigan sentencing guidelines and try to give you an idea as to what he thinks the court may do for sentencing. The question I have for you is, has he or anyone promised you or asserted to you or led you to believe exactly what the sentence would be from this court?
No, sir.
I want to highlight for you, if he has talked to you about the guidelines, which I expect that he has, the guidelines are not mandatory. They are, however, a tool the court must use in establishing a reasonable and proportionate sentence. They are just that, a tool, and they can provide a recommendation, but the sentence is up to the court alone. Do you understand?
Yes, sir.
Knowing all that, do you still wish to enter the plea as we discussed earlier?
Yes, Your Honor.
As to count 1, carrying a concealed weapon, how do you plead?
Guilty.
And as to added count 3, the misdemeanor of brandishing a firearm in public, how do you plead?
Guilty.
Before the court can accept that plea, I need you to tell me what it is that you did that makes you guilty of those 2 offenses. Turning their attention back to May 3rd of 2025, here in the city of Cadillac in Wexford County. What happened? Were you driving a car? All right, just go ahead and tell me what happened.
I was driving a car and my vehicle was struck, and then I followed them because they didn't have a license plate,
Okay,
and things escalated.
they always do, but all right, keep going.
And when we got to the place, my passenger exited the vehicle and approached them, and that's when I had retrieved my firearm.
Okay, and what kind of firearm did you have?
It was a pistol.
And do you know what kind of pistol it was?
Yes, sir.
What was it?
A Glock 19 or a Glock 26
All right, and from where did you retrieve that?
in a gun case
And where was that gun case located?
in the trunk.
All right, so it was inside the vehicle.
Yes, sir.
Do you have a license to carry a concealed pistol?
No, sir.
Now, this trunk that you're talking about, is it, I know it's a Camaro, what year was it, or is your vehicle?
2010.
2010? Okay, and so does that have a separate trunk or does it have a hatchback? I think it has a separate trunk.
Yes, sir.
All right, now that firearm that you had inside that vehicle, you said it was in a case, is that correct?
Yes, sir.
Was there ammunition inside that firearm?
Yes, sir.
All right, when I say inside the firearm, the magazine was actually inside of it itself?
Yes, sir.
All right, thank you. Was there a lock on that box?
No, sir.
All right, thank you. Now, when you got the firearm, you brought it out, what did you do with it?
I just held it.
All right, and describe to me what you mean by held it. How did you hold it?
I
You
just
can
held
even-
it in my hand down by the side of my leg.
Okay, so in other words, it wasn't still hidden inside of a coat. It was something that another person in public could see.
Yes, sir.
And you did it in a way that this other person would see the firearm in a
Yes, sir.
public place. Is that right?
Yes, sir.
Okay, thank you. All right, Mr. Carnes, you believe the defendants provided a factual basis?
I do, Your Honor.
Mr. Harrison, do you agree?
I do. That's all.
Mr. Carnes, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. Harrison, how about you?
I am likewise unaware.
Mr. Carnes, I believe the court's in compliance with Mission Control 6.302.
Yes, Your Honor.
How about you, Mr. Harrison?
I do as well.
The court agrees and finds that the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for counts 1 and added count 3. Therefore, the defendant is found guilty of 1 and 3. Count 2 will be dismissed at the time of sentencing. Sentencing, Mr. Childers, will be done in probably about 4 weeks. It could be 5 weeks, depending on how holidays come up over the next couple months. Between now and then, an agent from the Michigan Department of Corrections is going to prepare a pre-sentence investigation report. One of these reports must be prepared anytime someone's convicted of a felony within the state of Michigan. This report will describe the offense, the pretrial agreement, any statements, information you make or provide, as well as include a scoring of the guidelines, which again are not mandatory, and it will make a recommendation as a sentence, which again is not binding on the court because the court determines the sentence. There are 3 steps that involve you in the preparation of this report. Number 1, when you leave the courtroom, you're going to go all the way down to the probation office. Do you know where the probation and parole office is?
No, sir.
Have you been doing anything with community corrections?
No, sir.
All right. Take the elevator or the steps because you're a young man and you can use exercise. We all can. They all end up at the same place. You're going to do a button hook out of the elevator, walk down the slight ramp. There's a door at the end of that. Open the door, go through the door. Second door on your left. As long as you enter that hallway, there are only 3 offices. If you say, hey, Judge Moore sent me down, they will all tell you where to go, okay? All right, now they're going to give you a packet. You're going to complete it, turn it back in. They're also going to schedule an interview with you. You have the right to have Mr. Harrison present during that interview. They will also give this report generally to Mr. Harrison about 2 weeks prior to us coming back to court. You need to make sure that you stay in contact with Mr. Harrison. If there's any change of address or telephone number, you always need to let him know, but you also need to let the court know. He needs to meet with you prior to coming back to court because each side has the right to object to the scoring of the guidelines, ask for corrections or amendments to any of the information. So it's important that you go over it. Do you understand that?
Yes, sir.
Great, thank you. Any objection to continuation of bond?
No, Your Honor.
Your bond remains intact. You're going to be released here in just a moment. Heard from the defense, Mr. Harrison.
I have
No?
nothing.
All right, that's good. Mr. Childers, do you have any questions for me about what we have done today or what you're supposed to do between now and then?
No, sir.
All right, good enough. Thank you.
Thank you.
All right. We'll see you in about a month. We are adjourned.
Thank you.
It's the Courtroom Files Live on a Friday. It's Halloween. Michael Groff here. We're hanging out in Judge Elmore's court this morning. And he's doing some sentencing. We've got a pretty quiet morning in the court, so we're kind of just hanging out here, seeing what's going on. But I'm sure things will pick up here as we go through the morning. And I will tell you this right now. It is Halloween. So we are bound to, at some point, head out to Dungeon Court. Just a fair warning. That is probably going to come down the road here in just a moment. We've got, let's see if we've got anything else going on here with Judge Elmore. We're in the Wayback Machine a little bit here. We'll nudge this forward and see if he's got anything else going on. Well, what we'll have to do is we might just have to call an audible here and move over to Judge Simpson and see if he's still got his landlord-tenant docket going on. Do we not have audio again? No, apparently not. All right. Those ghosts and goblins take over. All right, let me get you back the audio. My goodness gracious, what is going on here on a Halloween? Oh, my. All right, let's do this. My apologies. This is a very professional operation that we're running over here. I have my monitor up to make sure that this kind of thing, that I notice it, but sometimes it takes me a moment because, there is a delay. So here we go. Back to Judge Simpson briefly.
Oh, what's your name?
Justice Richter.
All right. What is the claim?
Your Honor, we have rent routine of $1,498.09. Court costs of $230 for a total of $1,728.09.
All right. Ms. Richter, how are you intend on getting that paid?
So I do plan on having it all paid up by Monday, as well as November's rent.
Okay.
The reasoning for me not having it paid was my brother, I'm his sole caretaker, and we found out he has to have another open heart surgery. So I honestly forgot about rent. And then I'm like, oh my goodness, I gotta pay rent. So it was kind of just like life. So I plan on having that all paid.
So your brother was having surgery and you forgot about rent?
Well, I've been going to his doctor's appointments. We're scheduling his open heart surgery.
Got it.
Yeah, and this is our first
No, you
big
know what,
since my
Ms.
mom
Richter, I kind of said that facetiously. I get it. All right. Okay, I understand that. So you think you can get this all paid by Monday, including November?
100.
So here's what I'll do. I'll adjourn this to November 7th, 2025 at 2 p.m. Now that's an in-person hearing, but if you have everything paid, just double check and make sure you got everything paid. They're gonna dismiss this case.
Okay,
Okay?
thank you.
You are so welcome, and good luck to you, and best wishes for your brother.
Thank you.
Thank you.
Sile Farms versus Lawrence. It's a Brantel and Kill Brantel.
Casey Matson on behalf of plaintiff.
They are not checked in. You may proceed.
Thank you, Your Honor. We're requesting entry of a default possession only judgment. Rent to retain is $2,065.67. Court costs of $230 for a total of $2,295.67 with a writ to issue after November 10th.
Judgment to the plaintiff. That's by default for possession. Redemption amount in the amount requested. Writ to issue in 10 days.
Thank you.
Valley Ranch versus.
All right, let's go back to Judge Elmore. Looks like he's got another sentencing coming up. So let's see what's happening over there. We're doing a little bit of the Michigan Monster Mash here on a Halloween, but should be interesting to see what happens with Judge Elmore. Okay.
For some lab results. Therefore, not going on the record. Thank you. We're adjourned.
Thank you, Your Honor.
Oh. Well, that wasn't me that did that. That was all right. It's a slow day in the courts today, and we have all these interesting cases, but Judge Elmore has another contestant coming in, so let's see what this is all about.
FH appearances from counsel, please.
Joanna Carrier for the people.
I'm Jeff Harrison. I'm here on behalf of Mrs. Crocker. She's making her way up to the desk.
Thank you. We are here today for a pre-trial conference I conducted at counsel informed me that we are going to enter a plea pursuant to a pretrial agreement. I understand that the defendant, who is currently charged with possession of methamphetamine as a second or subsequent enhancement and or a fourth habitual enhancement, those counts will be dismissed, but she'll plead to an added count 2 of use as a second or subsequent, which makes it a high court misdemeanor punishable by up to 2 years and or $2,000. Is that correct, Ms. Carey?
It is.
Mr. Harrison?
That comports with my understanding, Judge. Thank you.
You all may be seated. Ms. Crocker, is that how you wish to resolve the file?
Yes, Your Honor.
Please raise your right hand. Do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, nothing but the truth?
Yes.
You may lower your hand. Ms. Crocker, looking back on July 23rd of this year, were you on probation, parole, or bond?
I was on probation, Your Honor.
Has there already been a probation violation conducted?
Yes.
Yes,
And did you already receive a sentence for that?
yes.
All right, thank you. You are currently charged on the felony information today with, as I mentioned, a single count of possession of methamphetamine, which is generally a felony punishable by up to 10 years and or up to $15,000. There are, however, 2 sentencing enhancements that could be taken and added to that sentence within the court's discretion. The first is a second or subsequent drug offender enhancement that could increase increase that maximum punishment from up to 10 to up to 20 years, and from up to 15,000 up to $30,000. Or on the alternative, you could be sentenced as a fourth habitual felony enhancement. That could increase in the potential punishment from up to 10 years to up to life. However, I'm told today that if you're going to enter a plea of guilty to an added count 2 of use of methamphetamine, which it alone is a misdemeanor, punishable by up to a year and or $1,000, but you'll also plead as a second or subsequent drug offender, which will increase that to punishable by up to 2 years and or up to $2,000. And the other counts will be dismissed. Is that what you understood?
Yes.
Is that how you wish to continue to proceed?
Yes, Your Honor.
Now, by entering a plea of guilty, you're not going to have any trial of any kind. You'll be waiving certain rights that you would otherwise have at a trial. That includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to presume to innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses presented against you, the right to have the court order any witnesses you may have for defense to appear at the trial, the right to remain silent in the trial, the right to not have witnesses against you, and the right to testify if you're to choose to testify. Ms. Crocker, do you understand those rights?
Yes, Your Honor.
And more importantly, do you understand that if you plead guilty as I described and I accept that plea, you will be forever waiving those rights as they apply to this particular case?
Yes.
Additionally, any appeal as to conviction and sentence pursuant to the pretrial agreement will be by filing an application for leave to appeal and not a claim of appeal by right. Furthermore, you may be given up the issue to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of some promise, threat, or inducement not told to me today on the record. Ms. Crocker, other than the terms of the pretrial agreement that we've already discussed, have there been any other promises, threats, coercion, duress to get you to plead guilty that we haven't talked about?
No.
Therefore, are you entering the plea of your own free choice?
Yes.
Now, Mr. Harrison's probably talked to you about Michigan sentencing guidelines and try to give you an idea as to what he thinks the court may do for sentencing.
Yes.
Has he or anyone promised you, however, as to what exactly the sentence would be?
No.
So we're standard of the plea as we discussed.
Yes.
As to added count 2, use of the controlled substance methamphetamine, how do you plead?
Guilty.
Before I go into that, I'm just going to ask also, is it true that on or about March 21st of 2024, you were convicted of possession of methamphetamine in this court? All right. Thank you. Turn your attention to July 23rd of 2025. Tell me, in the city of Cadillac in Wexford County, what happened? How were you caught in possession with this substance?
I was pulled over.
Okay.
And the search of the vehicle was done.
Mm-hmm. Methamphetamine found in the vehicle?
No, the pipe was.
The pipe was, I'm
Yes.
sorry. So you
Same
had,
thing.
so is it true then that pipe, you had used it recently or on or about that date or time for the consumption or use of methamphetamine?
Yes.
Did you have any lawful right in your mind to consume that controlled substance?
No, sir.
And did you know that it was a controlled substance?
Yes.
Thank you. Ms. Carey, did we should provide a factual basis?
I do.
Are you aware of any other promises, threats, or inducements?
I'm not.
Do you plead the court's compliance with Protocol 6.302?
Yes, sir.
And Mr. Harrison, do you agree with all three?
I do.
The court agrees and finds that the defendant's plea today is made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the elements for the added count 2. Therefore, the court finds her guilty of added count 2, use of the controlled substance methamphetamine, a second or subsequent drug offender. Ms. Crocker, the case will now be set for sentencing. I know you recently went through a sentencing, and I know that you had the other pre-sentence investigation report. I need to have a new report done. One must be done anytime when someone's convicted of a felony in a state court in Michigan. Even though most of that report will basically be just copying and cutting and pasting what was from last year's, you still need to go downstairs and they'll give you a packet, you complete it, turn it in, and they'll have you come in for an interview, and you have the right to have Mr. Harrison present during that interview. And then Mr. Harrison will meet with you prior to coming back to court for sentencing and go over the contents of that report. All right, so when you leave the courtroom today, you're gonna go downstairs to the probation and parole office. I know that you know where it's at, and tell them you need to do another PSI.
Okay.
All right, do you have any questions about what we have done today, Mrs. Crocker?
No.
Any objection to the continuation of bond, Ms. Carey?
No.
Anything further on behalf of the defense?
Nothing further, Your Honor.
All right, bond hereby continues. Ms. Crocker, make sure you continue to be compliant with your bond. Did I terminate your probation?
I believe so,
Yeah.
yes.
So all right, otherwise I would have said, make sure you're compliant with your probation, but make sure you're compliant with the terms and conditions of bond. How you do on that is very important to the court. And if you are getting treatment, I encourage you to do so. If you're not, you can even stop by community corrections and say, hey, can I get into an enhanced outpatient program, some kind of outpatient treatment? Doing that will go a long way to this, with this court about what to do with sentencing. All right, do you have any questions of me, Ms. Carter?
No, sir.
All right, thank you very much for your time. We're adjourned.
Thank you.
All right, it's the Courtroom Files Live. It is Friday, it's Halloween. And you know what else it is? October 31st. As you may have seen in the chat, it's Michelle's birthday today. Michelle, if you're wondering, that's my OAO, the sweetest of all time. The Asian sensation, the proprietor of sweetchildaz.com.org and the Facebook page at the same name, Sweet Child Arizona. And also, she is doing a great job filling in and helping out because this operation, it's kind of a one-man show normally when Dan's running this thing, but sometimes I need a little bit of help. So Michelle is here to help as well. Now, let's see. Where are we going to go next? You know where we haven't gone in a good long while? It's probably been a few months since we've done this. Let's head over to El Paso. We've got the jail magistrate court. And let me see if I can bring that up. Here we go. It is jail magistrate court from El Paso. Something a little bit different here on a Friday.
Mr. Olivas, who are you here on?
Damien Avalos, Judge. Damien Rene Avalos.
Okay. Downtown officer, can you log on or turn on your screen? Ms. Quevedo, are there any housekeeping matters?
Good morning, Judge. Yes, I have two waivers. Angel Hernandez and Angel Herrera.
All right, Angel Hernandez is now waived and we don't need him.
Angel Gabriel Hernandez, Judge?
No, Angel Armand, which one, Ms. Quevedo? There's two.
Oh.
It's probably Angel Gabriel Hernandez. Okay, and who was the other one, Ms. Quevedo?
Angel Herrera.
And Angel Herrera.
Yes, Judge. Angel Herrera is canceled?
Yes.
Okay. So Angel Gabriel Hernandez is also canceled, Judge?
Ms. Quevedo, there are two Angels Hernandez. One is Angel Armando, the other is Angel Gabriel.
Angel Gabriel, Judge, the one that has the probation hold.
Okay.
Okay.
So Angel Armando Hernandez is still on. All right. Anything else, Ms. Quevedo?
Judge, the other Angel Hernandez has been released.
Angel Armando Hernandez?
Yes, sir.
Okay, he posted bond. Okay. Anybody else who posted bond, officer?
Yes, Judge, is Burciaga Guy
Okay.
and Angela Reyes.
Burciaga Guy and Reyes. Okay.
Those are the only three, Judge. And I am showing that we do have an FFJ later.
Okay. We will do that whenever you get to that floor.
Yes, sir.
Do you happen to have Mr. Avalos on that floor?
Yes, sir.
Okay. All right. Good morning, Ms. Kaplan.
Avalos. Good morning, Your Honor.
Is there anything on behalf of the state before we begin?
Not at this time, Your Honor.
All right. Good morning, Mr. Avalos.
Good morning, Your Honor.
All right, Mr. Avalos is here on a driving while intoxicated, $27,000 bond split, risk assessment level 4. This is the only case that it appears he has. He failed to appear. And he says he's not sure how much money he has for bond. Mr. Olivas, go ahead, sir.
Thank you. Good morning, Your Honor. Your Honor, Damon Avalos is a 25-year-old U.S. citizen. He was born and raised here in El Paso. He graduated from Chapin High School. He was previously employed for the last 3.5 years at Hyundai of El Paso. I contacted his employer, his manager, Cesar Martinez. That job is waiting for him should the court release him. Your Honor, his permanent address, 4125 Casper Way in El Paso, Texas. He is the father of a 7-month-old baby girl named Michelle, Judge. Mr. Avalos has his failure to appear, Judge, is because he was previously, and I have the case, he was previously on supervised release with Judge Guadarrama on case number EP 20 CR 02313 for possession charge. What happened, Judge, is once the federal court finds out that he'd been arrested for DWI, they proceeded to revoke his supervised release. That was his bond was surrendered in May 5th of this year, and he was promptly arrested May 7th. As a result, Judge, he did not appear in court and has been in custody of the federal marshals. His case has been adjudicated in front of Judge Guadarrama, and he was released October 10th, Mr. Avalos?
October 29th, sir.
October 29th. And, well, that's his date of release. Anyway, he's been given credit. He has finished with his federal obligation, Judge. I guess what I'm trying to impress on the court is he did not fail to appear. He was just arrested and in federal custody and could not attend the August 7th hearing with Judge Gonzalez in County Court Law Number 4. That federal case is completely resolved. He no longer owes them any time. He was sanctioned, and he's currently off of supervised release. Your Honor, he had posted a cash corporate surety bond. As a result of his incarceration, he has no monies, Judge. His mom lives in Washington State. His father lives here in El Paso, but I've spoken to them both, and frankly, they are stretched. He had previously posted a bond. We're respectfully asking that this bond, the $25,000 cash corporate surety, if it could be converted to a straight up $25,000 PR bond with the requirements that he have the ignition interlock, and Judge Gonzalez also ordered intensive DWI supervision. We respectfully ask that it be converted to that so that he can get his life back on track. Your Honor, he has no prior DWIs. This is his first one. However, it's a 0.15 or above. Respectfully, Judge, we're asking this court to grant him a PR bond so he can get back to work and get back with his family.
Thank you. Ms. Kaplan, what says the state?
Your Honor, I'm showing a prior DWI conviction from June 15th of 2018, Your Honor, as well as a prior possession of marijuana less than 2 ounces conviction from June 9th of 2011. Oh no, that's sorry. I was looking at a different case. My apologies. No objection.
All right, I'm going to reduce this bond to $10,000. It'll be a personal recognizance bond. Mr. Avalos, you are ordered not to use drugs or alcohol, submit to random urinalysis, stay in contact with the PR bond office, and do not commit any further crimes. In addition to that, if you're operating a motor vehicle, it must have an ignition interlock installed. If you're not operating a vehicle, and you may not use any other vehicle unless it has that device. If you're not driving, you're going to have a portable alcohol monitoring device. You are going to have a curfew from 8 p.m. until 6 o'clock in the morning unless you're working or going to school. Do you understand?
Yes, sir.
Okay, now, one of the one of the notices of violations that was received by Judge Gonzalez was that you had skipped 19 tests during a period of time where you were out on bond. Okay, that was prior to you being arrested. You need to make sure that you comply with all conditions of your PR bond, including the breath test. Whenever you have to blow into the machine, make sure that you do, otherwise your PR bond is going to be revoked. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, Your Honor.
Ms. Lopez, any questions?
No, Judge, thank you.
Mr. Olivas, anything else on behalf of the defense?
No, Your Honor. Thank you for your courtesy.
Thank you so much, Mr. Olivas. Have a good weekend.
I'd be excused. Thank
Yes.
you.
Missing 19 tests. I haven't seen anything like that since I was in school. Good morning. It's the Courtroom Files Live. Want to thank Mama Joan, Grandma TCF, for $10 super chat, and Barbara for the gifted membership. The super chats and super stickers while Dan is on hiatus go to me. The channel memberships, of course, help and support this channel, and all of that is wonderful and awesome, and we do appreciate that. Now, back to the jail magistrate court here in El Paso.
He has $50,000 in assets. Risk assessment level puts him at a 3. Prior DUI, 2021 DUI, which was dismissed. And that appears to be all of his criminal record. He says he has $10,000 for bond. Ms. Quevedo?
Thank you, Judge. Mr. Tullius, I'm sorry. So you can afford the bond?
No, how are you going to remove the money?
If you're released from jail, where would you live?
I'll go to a homeless shelter.
How long have you been in El Paso?
Only like 6 months.
Where are you from?
Houston.
And what brought you to El Paso?
Secret Service mission. You have to talk to the U.S. Customs and the U.S. Marshals.
Okay, what is the highest grade of school that you finished?
Harvard.
I'm sorry?
Harvard. It's classified. You just, how can I explain it now? It's just go to the Pentagon or the White House.
Judge, would you like us to reset it for safety clearance?
No, man. I just would like to get out.
Judge. Sorry, Judge, you're on mute.
How old is this defendant, Ms. Quevedo?
I have, how old are you? What's your date of birth, Mr. Tullius? I have him as
1993. I'm 32.
32 years old. Have you read the complaint affidavit, Ms. Quevedo? On the unlawful carrying of a weapon, Ms. Kaplan, could you read the complaint affidavit?
You could try it.
I only have the act for the possession, Judge. I'm sorry.
You only have the act for the possession? Okay, well, the misdemeanor has been filed already under case number 2025 OCO 7147. Unless I'm wrong, it does not state a crime under Texas penal law, under the statute. Okay?
Ms. Kaplan, would you be able to either send it to me or?
They're alleging that he had
I'll send
a
it.
gun on
I'll
his
send it right now.
person.
I'll send it.
They're alleging he had a gun on his person inside of his jacket that was not in a holster. And that's the basis for the complaint affidavit and for the arrest. Is that a requirement, Ms. Casas, Ms. Kaplan?
That a gun be holstered?
That a gun be holstered when you're walking around, when you're not on a vehicle?
Judge, if you read 4603, I believe that is what is required, but we will go back and look at the law just to make sure, Judge.
He wasn't in
And Ms. Gavello, I teamed you the affidavit.
Okay, thank you.
Thank you. Yes, but Judge, we will take a look at it.
Okay.
While Ms. Kaplan handles the other hearings, I'll start looking at this one and look at and compare it with the law.
I don't think that's the law. Okay, the only time that a gun has to be holstered if it's in your vehicle, if you're operating a motor vehicle and the gun is in plain view and you don't have a license to carry a concealed weapon, then it must be holstered. And if it's not, then you're committing the offense of unlawful carrying of a weapon. But if you're just walking around and you have a gun in your jacket, it doesn't have to be holstered. Okay, it's dangerous, but it's not a violation of the law. But in any event, all right, Ms. Quevedo, I am going to reset this matter. I'm going to appoint the public defender's office because I don't believe he has $50,000 in assets. I'm going to reset this matter to next Thursday. The 6th of November. And 1:30 p.m. What was the substance that he had in his possession, Ms. Kaplan?
It was methamphetamine,
How much?
1.65 grams, and it was at the bottom of the 38 caliber cylinder.
Yeah. But the only way that he can be charged with unlawful carrying of a weapon if he's committing another crime, if he's inside of his vehicle or in a vehicle that he controls and is operating. Okay. All right, Mr. Tullius, thank you. Your case is being reset to next Thursday at 1:30 p.m. for a safety plan. Have a good day.
Thank you.
Davidson.
Who's next?
Davidson, Judge?
Good morning, Mr. Davidson.
Good morning, Your Honor.
Is this the FFJ?
No, Judge.
Okay, Davidson. Mr. Davidson is here on a resisting arrest, and he has a PR rebel out of the 384th. Ms. Quevedo, does he want to go forward on the misdemeanor?
Sorry, Judge, he declined the interview this morning. Mr. Davidson, you have a $10,000 bond out of the 384th, which means that that's with another judge. Okay? Do you have money to post that bond?
I don't, ma'am.
Okay.
No.
So what that means basically is that unless you need to go see that judge, because otherwise you're going to be in custody anyway on that case. So my recommendation would be to waive this hearing so that you get credit for your time in jail, since you're not going to be able to bond out right now because of that other high bond. But we can go forward if you want. Whatever the decision is yours. So in other words, and I'm sorry, I would have explained this more slowly and answered any questions this morning had you come to the phone. But in other words, since you're not going to get out of jail anyway because you can't afford the other bond, and that case isn't before Judge Nunez, the better thing to do is to waive this hearing so that you get credit for your time in jail on the resisting, on the misdemeanor. Does that make sense? Do you have a question? Okay.
All right. Thank you, Mr. Davidson. I'll mark you as waived for today's hearing. Have a good day, sir.
That's it for this floor, Judge.
All right, we'll be in recess. Thank you.
Judge, I have one ready for you. I have Mr. Deanda Isaac ready.
Deanda, good morning, Mr. Deanda.
Good morning, Your Honor.
All right, Mr. Deanda is here for assaulting a family member by choking. $3,000 bond. Risk assessment level is a 2. No priors. Ms. Quevedo?
Thank you. Mr. Landa, if you're released from jail, where would you live?
The barracks on base, Fort Bliss.
Okay, and how long have you been in El Paso?
I've been in El Paso since February of 2024.
Where are you from?
I'm from Mission, Texas.
Okay, yes, I did speak with Mr. Landa this morning, Judge. I don't know why it didn't say, but in any case, I remember now I did speak with him. And then You told me you graduated from high school in where?
Elsa, Texas.
Okay, Texas, yes. So you have been in the Army since 2024?
2023.
2023, okay. And can you repeat the number where you'd be available if you are released, please?
210-563-9724.
Okay, and you had indicated, I think, that you do have some money to post, but you haven't spoken to a bonding company because you get paid today, correct?
Today at 10 o'clock at night. Yes, ma'am.
Okay. So Judge, we are respectfully requesting a PR bond or any relief the court might find fitting, since I don't know if he would qualify for the traditional 10% or not because he's in the Army. Thank you, Judge.
How much money is he going to have available after he gets paid today to post the bond?
He had indicated that he'd have enough for the 10%.
I'll have the $300.
How much more money will you be able to have after you get paid today?
That's it. I have to pay rent and keep my wife and my child fed.
All right, thank you. Ms. Kaplan?
Your Honor. There's a military detainer in this case. Mr. Deanda is a U.S. Army service member. He's an E4. He has a small baby and a spouse. And due to the violent nature of the offense, I have safety concerns for the victim and the community if he were released.
What were the allegations?
So the allegations were that he got in an argument with his spouse, Miss Karen Puerto Rodriguez, over cleaning up the house to prepare for the baby's therapy. He suffocated her by putting a pillow over her face, and she was not able to breathe.
That's a lie, Your Honor.
Okay.
And Judge, just
Thank
to be
you.
clear, he does understand the protective order in place, which is why he'd be living at the barracks, just
All right.
to address Ms. Lindsay's concern.
All right. All right, considering that he is a soldier with the United States Army, considering that he does have a military hold, he will be required to reside at the barracks. I'm going to reduce his bond to $250 in cash with conditions. The conditions are as follows. You are ordered not to use drugs or alcohol, stay in contact with the PR bond office, and do not commit any further crimes. You are to have no offensive contact with the complainant. You may not go within 200 yards of her residence or place of employment. You may not possess any weapons, firearms, or ammunition unless you are required by the United States Army. Do you understand?
Yes, Your Honor.
Okay. Mr. Deanda, you're going to need to stay away from your wife, at least for a while. Okay.
Yes, Your Honor.
If she decides that she wants to see you, it's going to have to be away from the house where she lives. Do you understand?
Yes, Your Honor.
If she invites you over to the house and you are within 200 yards of that residence, you are in violation of my order, you are in violation of the protective order, and you are subject to arrest. Understood?
Yes, Your Honor.
All right. Thank you and have a good day, sir.
Likewise, thank you.
Okay, Judge Mr. Flores, Victor is next.
Judge, sorry, what's the supervision level for the previous?
Intensive level.
Good morning, sir.
Good morning. What is your name?
Victor Flores.
Mr. Flores. Mr. Flores is being accused of aggravated assault with a deadly weapon. He refused to provide us financial information, so we cannot determine whether or not he qualifies for a lawyer. Risk assessment level is a 4. He's got a misdemeanor failed to stay at an accident from 2017 out of Arizona. And we don't have any information regarding who he is, where he resides, and how much money he asked for bond. Ms. Quevedo?
Thank you, Judge. Your Honor, Mr. Flores lives with his grandparents at 115 566 James Grant. Sorry, Judge, the grade school is calling me. May I check just to see if
Yes,
it's a
go ahead.
recording? Is it okay? Okay, sorry, it was just the recording that they have early release today. Your Honor, he has been in El Paso for about 7 years. He is a U.S. citizen. He indicated that he graduated from high school in 2016 in Arizona. In El Paso, Judge, he has his grandparents, his aunt, his husband, and his cousins. He works at a flooring company, Judge, which he owns in part. He has phone number 915-926-0513 where he can be reached. That is his grandmother's number. And he is not sure how much money he'd be able to put together. He indicated that he's trying to borrow money from his family. So we are respectfully requesting a bond reduction or any relief the court might find fitting. Thank you, Judge.
So he's a partial owner of a flooring company?
Yes.
But he's trying to buy it from his grandfather.
No, my stepfather already bought it from my grandpa. I'm just running it from my stepdad.
Okay, but he says he's part owner of it. What is the value of that company?
I mean, the property in itself, $1 million. The company, I mean, I can't really, I mean,
No.
can tell you
So
exactly.
you own 50% of a property that is worth $1 million.
I don't own it. My stepdad does. I just run the company, but I make enough money to pay whatever I need to pay. I mean,
How much money do you make per month?
I mean, I make $1,000 a week, so $4,000 a month.
Okay, all right, thank you.
No problem, sir.
Ms. Kaplan,
Yes, Your Honor.
go ahead.
Regarding Mr. Victor Flores, the state would request an emergency protective order with no contact for the safety of the victim, Miss Melissa Bonda. She is in fear for her life after the incident involving the AR-15 rifle, and the state respectfully requests that, considering the safety of the victim and this that an emergency protective order with no contact be issued at this time.
Okay, what happened in this case, Ms. Kaplan?
So it appears that the defendant discharged an AR-15 rifle after the victim, Miss Melissa Bonda, and the defendant got in an argument after leaving a restaurant. The defendant was in the process of driving the victim back to her vehicle. 5 minutes into the drive, the defendant reached for an AR-15 that was in the backseat of the vehicle and discharged it while driving down Donovan. The victim felt the concussion of the gun being discharged and felt pain on her back, and she believed she had been shot initially, and she is in fear for her life at this time due to the incident.
Are they in a relationship, Ms. Kaplan? Are they boyfriend and girlfriend?
I believe so, Your Honor, although I could be mistaken.
Yeah, we are.
Mr. Flores, it's not a good idea for you to be making statements, okay? Whatever you're saying is being recorded down and it could be used against you in the future. Do you understand that?
Yes, sir.
Okay. Going to reduce his bond to $20,000 cash corporate surety with conditions. The conditions are as follows. You are ordered not to use drugs or alcohol. Stay in contact with the PR bond office and do not commit any further crimes. In addition to that, you are to have no contact with the complainant. You must stay at least 200 yards away from a residence. You may not possess any weapons, firearms, or ammunition. Do you understand those conditions, Mr. Flores?
Yes, sir.
Do you have any questions?
No, sir.
All right, thank you and have a good day.
Likewise.
Mr. Limon Edward is gonna be next. Your Honor.
Judge, may I be provided with the address for the complaining witness?
Ms. Kaplan, can you put the address of the CW in the chat room?
Yes.
I will provide it.
Okay, thank you, Ms. Casas. All right, sir, what is your name?
Edward Limon.
Good morning, Mr. Limon.
Morning.
All right, Mr. Limon is here for an assault against a family member, $50,000 bond. Risk assessment level has him at a 4. 2014 criminal mischief conviction out of Midland, Texas. 2014 conviction for assaulting a family member out of the same county. Resisting law enforcement officer without violence out of Florida in 2022. He's currently on deferred adjudication for a 2019 case, felony, for assaulting a family member with previous conviction. He's got a juvenile adjudication for assaulting a family member, and he also refused to provide us any information regarding his residence, where he will reside, where he is employed, or any community contacts. Ms. Quevedo?
Judge, Your Honor, Mr. Limon stated that he would live with his father at 12976 Emmanuel Vista. He's lived most of his life here in El Paso. He is a U.S. citizen. He attended Americas High School, where he completed up to the 11th grade. He has 2 daughters. They're 6 and 7, and then he has another child on the way. He has his children, his father, as well as his sister here in El Paso. He works painting houses. He can be reached at 915-701-1599, which is a friend's number. He has no money to post, Judge, so he is respectfully requesting a PR bond or any relief the court might find fitting. Thank you, Judge.
Thank you. Ms. Kaplan?
Yes, Your Honor. Due to the past family violence convictions and the fact that Mr. Limon is currently in jail for assault family violence against his girlfriend, because there was a fight that ensued over his keys. He wanted to drive, and his girlfriend believed he was intoxicated and did not want him to drive. He pushed her and slapped her across the cheek and scratched her arm. For her safety and the past family violence convictions, the state requests that the court consider not lowering the bond at this time, or not awarding a PR bond due to the nature of the incident and the safety of the victim in this case.
Was it more than just 1 or 2 slaps across the face, Ms. Kaplan? Was there punching and kicking involved in this case?
The affidavit says that she was pushed and that she was slapped across the cheek and that her arm was scratched, Your Honor.
Mr. Limon, I'm going to reduce your bond to $20,000 cash corporate surety with conditions. The conditions are as follows: intensive level supervision, don't use drugs or alcohol, stay in contact with the PR bond office, and do not commit any further crimes. In addition, you are to have absolutely no contact with the complainant. Do you understand that?
Yes.
You may not go within 200 yards of her house or place of employment. You may not possess any weapons, firearms, or ammunition. Are you working?
Yes, I am. I'm currently painting a house right now.
Okay. What time do you work? What
I
are
work from I usually work from 8 to 5. It just depends. If I have to work late, I'll work late. But
Okay, you're gonna have a curfew from 8 p.m. until 6 o'clock in the morning. Do you understand that?
yes,
Okay, have a good day, sir.
thank you.
It's the Courtroom Files Live on Halloween. Yes, Friday the 31st of October. The year is flying by. Only 2 months left in this year. My goodness. All right, the court's kind of slow this morning. We've got landlord-tenant going in a couple of courts, and unless it's Judge Simpson, we kind of try to avoid that typically, although sometimes those can get a little spicy. Speaking of spicy, We're coming up on the noon hour on the East Coast, and that means it's hangry time down in Miami-Dade. Let's see what's happening with Judge Glazer.
Person in writing, by telephone or through third parties. No contact with the victim through social media or other electronic means. You must stay at least 500 feet away from the victim, her home, school, and any place of employment at all times. Do not engage in any criminal activity. Do not use or possess drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. And sir, you return to the victim's residence one time only within 48 hours of your release from jail. If the victim's moved out, you can go back, but if she's still living there, you got to find somewhere else to go. You can return there one time only within 48 hours of your release from jail. You must be accompanied by a police officer so that you can retrieve your personal clothing, health items, medication, personal business-related paperwork, and work tools. If you go to the victim's home without the police, or if you stay there, you will be arrested. Do you understand? Stay away with it.
Yes, ma'am.
All right, I'm setting a bond. Count one is $5,000. Count two is $5,000 for the false imprisonment. Good day, sir. Next is Jill Alvarez, page 13.
Mr. Albertson, I'd say for immigration.
He speaks Spanish.
Okay. Good afternoon, sir. You were arrested for two counts of trafficking in crystal meth, one count of possession with intent to sell fentanyl, and one count of possession with intent to sell crystal meth.
Buenas tardes, señor. Usted fue arrestado por dos acusaciones de andar en tenencia de metanfetamina en intención de tráfico, además de haber estado en tenencia con intención de venta de fentanilo. Your Honor, what was the third one?
Possession with intent to sell crystal meth.
Y además de haber estado en tenencia con la intención de venta de cristales de metanfetamina.
So I will appoint the public defender's office for you.
Le asigno al abogado de oficio para que le represente.
So there's on October 21st.
Your Honor, can you repeat for the interpreter?
The sale of crystal meth on October 21st. It was 14 grams.
Muy bien, aquí se indica que hubo una venta el 21 de octubre por 14
And
gramos.
another one on the 23rd.
Y otra el 23, dice la fiscalía.
And then the search warrant, but they didn't find much.
Y después hubo una búsqueda de cateo, pero no
They
hallaron
found
mucho.
a 1.1 gram of fentanyl with cocaine and 0.7 grams of crystal meth.
Encontraron 1 gramos de fentanilo y cocaína y 0.7 de cristales de
So
metanfetamina.
counts 1 and 2, there's probable cause for trafficking in amphetamines. It's a $1,500 bond count 1 and $15,000 bond count 1, $15,000 bond count 2.
En los cargos 1 y 2 tenemos $15,000 de fianza en cada uno.
Count 3, there's probable cause for possession of fentanyl. That will be $2,500.
En la acusación de tenencia de fentanilo, la acusación número 3 van a ser $2,500 de fianza.
Count 4, there's probable cause for possession of the crystal meth. That will be $2,500 bond.
Y la acusación número 4, la tenencia de cristales de metanfetamina, $2,500 de fianza.
Have a nice day.
Tenga buen día.
Next is Ursel King. Page 14. Good morning, Mr. King. You were arrested for 2 counts of aggravated assault with a deadly weapon. I will appoint the public defender's office for you. All right, this is for 2 counts of aggravated assault with a firearm. So you are ordered to stay away from the alleged victims, Timothy and Drell Everson and Sunita Devandra Everson. No contact with these alleged victims, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victims through social media or other electronic means. And you must stay at least 500 feet away from the victims, their home and school and place of employment at all times. Do not engage in any criminal activity. Do not use or possess illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, munition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the stay we were saying?
Yes, ma'am.
I'm setting a bond. It's $5,000 bond each count. Listen, if you want to see your child, you got to go to family court and get it. Go on, file a petition to determine paternity and ask a family court judge to give you a parenting plan and time sharing schedule. All right. It's the only way you're going to get your child. I mean, it makes it easy so you don't have to get arrested trying to go see your child. There's a self-help office on the 24th floor of the Los Thomas Courthouse Center. They get do it on your own, or you can hire a lawyer. If you go there, they sell a package for like $65. If you can't afford it, they'll waive the fee. You fill it out. They review it with you after you fill it out, and then you can file it with the clerk of court. It's a petition to determine the paternity. And if you cannot afford the filing fee for the clerk of court, the clerk will waive the fee for you. So there's nothing stopping you going to court to try and establish your parental rights, know what days to see your child. And if anybody wants to deny you, then you call the police and they'll assist. Okay, but you can't do things on your own where you get arrested. All right. Have a good day.
All right, words of wisdom from Judge Glazer, although sometimes that audio can still be problematic. Believe it or not, they were actually working on that audio again this morning when I checked on the stream early. So I don't know. That is a cush job down in Miami-Dade. All right, let's head back to Judge Elmore. Another contestant looks like they'll be stepping on in, and we'll see what's going on there. And then pretty soon, we'll head to Dungeon Court.
9 FH. Appearances from counsel, please.
Community carry for the people.
I'm Jeff here. Mr. Burrows, he's making his way room into here.
All right. Mr. Burrows is currently in pretrial custody and being escorted here into the courtroom. You're here today for a pretrial conference I conducted earlier with counsel and chambers, and they informed me that we anticipate a pretrial agreement. That pretrial agreement will involve a no contest plea. You all may be seated. Madam Court Reporter, if I could please have a prosecution exhibit sticker. Thank you. Ms. Carey, the terms for the pretrial agreement, please.
Thank you. It's my understanding that the defendant is going to plead no contest. To and to count 4. Dismiss counts 1 through 3.
Yes.
Mr. Harrison, I suspect that's a complete and accurate statement of the pretrial agreement.
It is. I wanted to check one thing, Your Honor. I'm sorry.
Okay.
I was staring at the complaint as opposed to the information. The numbers didn't line up.
All right, so Mr. Burrows, is that how you wish to resolve today's case, sir?
Yes, sir.
To the best you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony that you're about to provide shall be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You may lower your hand. Sir, you are currently charged on a felony information with 4 counts. And I remind you that you just took an oath. Make sure everything you tell me today is true. You can't come back later and try to change your opinion or your statements.
Yes, sir.
There's not going to be a whole lot you're going to state because I know I'm told there's going to be a no contest plea. So on this felony information, the charging document, you're charged with 4 counts. I'm told that you're going to plead guilty to 2 of them, or sorry, no contest, and then 2 of them will be dismissed. By the way, a no contest plea is the same impact as a guilty plea. The difference is instead of requiring you to recite a factual basis, the court will look at something else to make a determination. Count 1 is a charge of assault with a dangerous weapon, also known as felonious assault. That's a felony punishable by up to 4 years and or up to $2,000. That count will be dismissed. Count 2 is a charge of assault, resist, or obstruct a police officer. That is a felony punishable by up to 2 years and or up to $2,000. That charge, I'm told, you're going to plead no contest to. Count 3 is a charge of domestic violence as a second offender. That is a felony, a misdemeanor punishable by up to 1 year and or up to $1,000. I'm told that that count will be dismissed. And last, you are charged with an attempted assault with intent to do great bodily harm, less than murder, or by strangulation. That's a felony punishable by up to 5 years and or up to $5,000. And again, I'm told that one you're going to plead no contest to. So far,
just for clarity's sake, the actual charged offense is the attempt to that.
Yeah, I thought I said that.
I'm sorry, I completely missed that. Then my apologies.
Okay. So it's an attempt to that offense.
Exactly.
All right. So far, do you have any questions as to what the terms of the pretrial agreement are?
No, sir.
Thank you. Now, by entering a plea of no contest, you're not going to have a trial of any kind. And you're going to be waiving certain rights that you would otherwise have at a trial. Now, that includes the right to be tried by a jury, the right to be tried without a jury if you chose, the court and the prosecutor consented, the right to be presumed innocent until proven guilty, the right to have the prosecutor prove your guilt beyond a reasonable doubt, the right to have the witnesses against you appear at the trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have in defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at the trial if you were to choose to testify. Mr. Burrows, do you understand those rights?
Yes, sir.
And even more importantly, do you understand that if you enter a plea of no contest and I accept those pleas, as we discussed earlier, you will be forever waiving those rights as they apply to this particular case?
Yes, sir.
Additionally, any appeal as to the conviction and sentence pursuant to the pretrial agreement would be by filing what's called an application for leave to appeal and not an automatic or claim of appeal by right. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. You will also be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me now on the record. Have there been any of the promises, threats, or inducements that we have not yet discussed to cause or compel you to plead guilty?
No, sir.
Are you into the plea there? I'm sorry, I said guilty. Are you entering the pleas of no contest on your own free will?
Yes.
Now, Mr. Harrison has probably done a good job and talked to you about potential sentencing and try to give you an idea as to what he thinks the court may sentence you to. He's also probably talked to you about the Michigan sentencing guidelines and try to give you an idea or estimate as to how you may score. The key question here I have for you is, has he or anyone told you or asserted you or led you to believe exactly what the sentence would be?
No.
I highlight for you any estimation of the guidelines are strictly that, they're just an estimation. And the guidelines themselves are not mandatory upon the court. They are, however, a useful tool that courts must consider. Do you have any questions so far about what I've discussed?
No, sir.
All right. So I talked to you a little bit about a no contest plea earlier. The court can take a no contest plea in a couple certain circumstances. One is if there's a potential risk of potential civil liability. In other words, you could be sued for a harm that was caused. Another could be intoxication where you may not fully be able to recall the events. And another may be in the interest of justice. I'm told here that there's a potential civil liability, and while there was no blood alcohol level provided, that there was a very obvious level of intoxication. You understand?
I do. If there's something I may add.
Yeah.
Not only was I intoxicated, Your Honor, but I was also under the influence of 17 different prescriptions.
Okay. So it's fair to say you may not really recall all the facts. Is that correct?
Yes, sir.
All right. And thank you very much for that clarification, Mr. Burrows. I accept that. All right. So, and again, I anticipate the plea to be no contest. I just remind you because people often will say guilty, even though because they just watch too much TV. So as to count 2, assault, resist, obstruct a police officer, how do you plead?
No contest.
As to count 4, attempt strangulation, how do you plead?
No contest.
Now, I was informed of this plea before coming into the courtroom, and the counsel provided me a copy of what has now been marked as People's Exhibit Number 1. Ms. Carey, are you offering this for admission?
I am.
Any objection, Mr. Harrison?
None.
People's Proposed Exhibit Number 1 for identification is hereby admitted. This exhibit is a incident report from the Westwood County Sheriff Department. Case number or incident number is 83-2500957. It consists of an original report that has 3 pages, and then it has a handful of supplements attached to it as well. They are stapled together, and I've taken the chance to read through them. I'll highlight that consistent with the felony information, it shows an offense date of May 31st of 2025. It shows a location of being within Cedar Creek Township here in Westwood County. As for the count 2, the assault, resist, or obstruction of law enforcement officers, specifically on the primary narrative that appears on page 1 of 3 and part of the supplements here. Toward the bottom, it talks about how deputies Johnson, Laws, and Deputy Ramirez of the Westford County Sheriff Department encountered the defendant, that he presented them with a golf club, that he raised it or quote reared it back and said no to their request that he comply. He also took a fighting stance and became verbally aggressive, and it looks like they had to use tasers. Additionally, again, there's evidence contained in this report that talks about the level of intoxication. As to count 4, there is information that begins to appear on page 2 of 3 of that same primary narrative, and is also covered elsewhere in the report, that there was a victim in the case. Her name was Nicole, that the defendant had hit her, looked like knocked her down onto the ground, and then he came up behind and quote, attempted to strangle her with his belt. comma, she was able to get her fist between the belt and her neck, period, end of quote. Ms. Carey, do you believe the interests of justice do not require the defendant to recite a factual basis?
I do.
Mr. Harrison, do you agree?
I do.
Ms. Carey, are you aware of any other promises, threats, or inducements?
I know.
How about you, Mr. Harrison?
Nor am I.
Ms. Carey, do you believe the court should comply with Scroll 6.302?
Yes, sir.
Mr. Harrison?
I concur.
All right, thank you. And Ms. Carey, do you believe that the report provides a factual basis to support a finding of guilt for the 2 counts?
I do.
Mr. Harrison?
I agree.
All right. The court agrees and finds that the defendant's plea today is made freely, knowingly, voluntarily. Also, based upon the information we've already discussed on the record, the court finds that the interests of justice do not require the defendant to recite a factual basis, as he may not be able to do so, and there is potential civil liability. Therefore, the court finds again that the facts are supported by the People's Exhibit, and the defendant is found guilty of count 2 and count 4. Counts 1 and 3 will be dismissed at the time of sentencing. Mr. Burrows, the case will now be set for sentencing. We typically do sentencings on Monday mornings. Generally, between a plea and a sentencing date, there's generally about 4, maybe 5 weeks, depending upon how the holidays fall in over the next couple months here. But anyways, we do them on Monday mornings. Every time someone's convicted of a felony charge in any state court in the state of Michigan, an officer of the Michigan Department of Corrections must prepare a pre-sentence investigation report. Now, this report will include a description of the offense, a description of the pretrial agreement, any statements or information you make or provide while this report is being prepared. It'll also include a statement from any victim, and it will include a rendition or report of your criminal history, how you've performed on bond, how you've performed on probation if you've ever had it. And it will also include a scoring of the guidelines and make a recommendation as to sentence. Please keep in mind that is merely a recommendation, as it is the court alone that determines the sentence. And as to the guidelines, as I've already mentioned, they are not binding, but they are a very important tool that the court must consider and discuss at the time of sentencing. The preparation of this report that I've mentioned involves you in 3 main ways. Number 1, you're going to get a packet of information. You're going to open it, follow the instructions, and complete it. That packet is been handed by the clerk over to the bailiff, and they'll give it to you when you leave the courtroom. Then you'll be subject to an interview with an agent from that department. You have the right to have Mr. Harrison present during that time of the interview. And number 3, Mr. Harrison is going to come and meet with you prior to us going over that for sentencing. You both need to go over because there might be need for corrections. Okay. Each side has the right, when we come back to sentencing, to raise objections or request corrections to the pre-sentence investigation report, as we must make sure that it's complete and accurate before the court uses it to base a sentence. Mr. Burrows, do you have any questions of me at this time?
Not at this time.
All right, thank you. Ms. Carey, anything further on behalf of the people?
No, thank you.
Mr. Harrison, how about you?
I would, with the permission of the prosecutor, of course, like to be heard on bond.
Ms. Carey, any objection to an oral verbal motion today on bond?
No.
I see right now that there was an original bond set on June 2nd at $15,000. Then there was a 10% on October 3rd set. That was at the district court level. That was set to $10,000. So that brings it down to $1,000. And there are terms and or conditions.
At this juncture, there are 2, I think, factors that are allowed, should be considered heavily by the court. First and foremost, as we've hinted or relayed even to the court, there was a period in time in which Mr. Burrows was being evaluated for competency.
In relationship to this particular case.
Yeah, and I have a feeling, I agree with the progression that he's made. While he was being evaluated in that process, I think they correctly found him to be competent. We've been able to proceed. In the meanwhile, he spent 153 days in custody. I believe that's an accurate number as of today. the agreement that we entered into before the court, both the prosecutor and I believe that his score will result at 0 to 17. And so it raises the obvious question here. I don't really know, or I don't know if we want to get in too far into the weeds with regard to good cause and that sort of thing. I would just like to make a pro forma motion based on the fact that I have a 0 to 17 guideline with 153 days credit as of today. Obviously, that will be substantially more by the time we get to sentencing. Thank you.
Ms. Carey, what can you tell me about the defendant's prior criminal history?
I'm looking at his lien right now. He has in 2004 a retail fraud third and operating in 2007, operating while intoxicated. In 2023, he had a possession of a firearm under the influence. 2016, he had like, apologize for my reading. He had an aggravated domestic violence. So
That was in
16.
All right.
I don't believe there's any issues with appearance or non-appearance, and I believe he's from our county. There is, though, a serious issue with alcohol. I believe the police report indicates his mom, who was the victim, indicates he drinks a fifth or something a day. Mental health is an issue.
And where does he live?
Well, this happened, I want to say in the Manton area.
16 in the end.
Yeah.
However, they were renting that house, that is no longer available, so I don't know where he will live. He was living with his mother, they were renting this house. In this incident, he threw a chair through a big bay window, there was a lot more to it.
I read the whole report, so I highlighted the things that applied to the findings for the 2 counts.
So
But yes,
his reputation for dangerousness is quite concerning. The
Yes.
seriousness of this offense, he also, as the report indicated, sicked his dog on his mother, who is
yeah, I saw
and
it.
caused injury to her, as well as tremendous emotional damage to his mother. I don't think we have any information regarding his employment history. I think that the bond, there's nobody from the community to vouch for him.
I got you. So
I think the bond is currently, as said, is reasonable.
I definitely don't think it's unreasonable, $1,000, considering the information that I've read inside the police report. Not only that, which I discussed on the record, but also there are several other factors that Ms. Carey has even mentioned, and there's more to it. And the prior criminal history and issues involving mental health, alcohol, and so forth. Definitely tend to lead me to believe that the bond is appropriately set. However, we're also at the phase where the defendant has now been found guilty of a couple serious issues. And also, while we do have a 0 to 17, we have an issue of violence.
Right.
And therefore, once we get into issues of violence, those presumptions that apply to intermediate sanction cells do not necessarily apply. And therefore, the court denies the bond modification. In fact, based upon the fact that he's found guilty, the court revokes bond and remands him to the custody of the Wexford County Jail. There, he can also continue to get treatment through Catholic Human Services for treatment of any alcohol issue. All right, thank you very much. We are adjourned. Oh, sorry, hold on. No, we need to do a DNA order because I didn't see any prior felonies, but
Correct. Do we do that today?
yeah, we'll do it right now. Thank you. You may go ahead and bring it. So we're still on the record. I said the word adjourned too early. Carrie, there's your exhibit. All right, Mr. Burrows, because this appears to be a felony, a DNA order must be signed. Anytime someone's convicted of a felony within the state of Michigan, you will have that DNA order exercised or taken out at the sheriff's department. Hold on. It is a simple swab of the inside of your mouth. I have signed that order, return it to the court. I'm sorry, to the prosecutor, make a copy to the clerk, and then she'll put it in the file. All right, thank you all very much for your time today. We are hereby adjourned.
Thank you.
Thank you.
All right, there we go. Got to talk with the mic unmuted there, Mike. Boy, oh boy, oh boy. Thank you, Barbara, for the $5 super chat. Mama Joan, thank you, $10 for Michelle, it says. And Ashley with the happy birthday to Michelle, $15 super chat. Thank you. And of course, thanking me for the hard work I'm doing. I'm just pressing buttons and doing things kind of derping around here on a Friday, but it's Halloween. In our commitment to give you 9 to 11% more Judge Boyd before we go to Dungeon Court here a little after the bottom of the hour, here is some Boy Oh Boyd. And let's see what we've got going on here because we have to give you Judge Boyd. If I'm running the show, it's always going to be Judge Boyd. So you know that.
Kelly Green. All right, who's next?
Both. Yes, we're ready. Wow.
All right. I was like, what? All right, John Anthony Cruz. And this is an application?
It is, Judge.
I'm sorry,
Judge,
I'm ready.
Application. Court is calling 2025 CR 008006, State versus John Anthony Cruz. Can I have parties announced? For the
Charles Buck
state?
for Mr. Cruz.
All right. And for the state? And are you Mr. Cruz?
Yes, ma'am.
All right. Counsel, you received all discovery. Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Cruz, did you review the application for community supervision with your attorney? Did you understand it?
Yes, Your Honor, I did.
And did you sign it?
Yes, Your Honor, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge, and we do not object to proceeding on count 2 with the state waiving count 1 and the enhancements.
Any state, is that what you're doing?
We are
Yes.
waiving the enhancement and we are proceeding on count 2 and we're waiving count 1. Yes, Your Honor.
All right, Mr. Cruz, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
The state is proceeding on count 2, possession of a controlled substance, penalty group 1B, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
No.
All right. So let me say that again. You understand you have a right to jury trial. You're giving up that right by entering this plea. Is that what you want to do?
Yes, Your Honor.
You have a right to remain silent. You're giving up that right by entering into this plea. Is that what you want to do?
Yes, Your Honor.
You have a right for you or your attorney to cross-examine any witnesses the state would call You understand you're giving up that right
Yes, Your Honor.
and entering into this plea?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses? Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Absolutely.
Mr. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Satisfied with the way you've been represented?
Yes, Your Honor.
If you're not a U.S. citizen, you will be deported, denied naturalization, or re-entry. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine. The state is opposed to your application of community supervision. There's no application for deferred adjudication, and the state is proceeding on count 2. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have any such motions?
No, Judge.
Then to count 2 in the indictment, how do you plea?
Guilty.
State any evidence.
State offers into evidence states exhibit 1 with its attachment.
No objections.
Mr. Cruz, did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor, I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Counsel, if you would like, we can set this for a sentencing date with a PSI or a,
December 11th, Judge.
all right. And you're requesting a PSI?
Yes, Judge.
All right, so we'll be back on December 11th. At that time, I'll make a decision on your application based upon any evidence that's presented. Do you understand?
Yes, Your Honor.
All right, good luck to you. Thank you.
Judge. Yes, please.
Yes, and tap evaluation.
We're hearing with Judge Boyd till a little bit past the bottom of the hour, and
Judge, it's
then
Kelly Green. I'm ready on Yvonne Perez.
get ready because it's about to get dark, very dark. But first, more Judge Boyd
Yvonne Perez.
via Memorex.
Court is calling 2025 CR 01067 State versus Yvonne Perez. If I may have parties announced for the defense.
Kelly Green for Yvonne Perez, the defendant.
And are you Yvonne Perez?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Are there any applications in this case?
Yes.
All right, counsel, the court does not have an did you file an application for community supervision?
Yes.
All right. All right, the court is not in receipt of any application for community supervision. State,
Yes, Judge.
do you have any objection to an oral motion for an application of community supervision?
No, Judge.
All right. So it's the court's understanding that you're requesting probation from the court, is that correct?
Correct, Your Honor.
All right. And so do you understand that there's an application that will say that you've signed it, you've understood it, and you know by signing that, you're letting the court know that you wish to be considered for community supervision. Do you understand?
Yes, ma'am.
All right. And do you understand that community supervision is a conviction on your record?
Yes, ma'am.
All right. Did you review the true bill of indictment with your attorney and understand it?
Yes.
Counsel, are you waiving the reading of the indictment?
Yes, I am.
State, are you proceeding on the indictment as presented?
No, Your Honor. State moves to proceed on the lesser included offense of theft of property less than $100 with a previous conviction.
Any
That
objection?
is correct, Your Honor. No objections.
All right. Did you review the court admonishments with your attorney?
Yes.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right. The state is proceeding on the lesser included offense of theft of property less than $100 with a previous conviction. That's a Class B misdemeanor. So the range of punishment is up to 180 days in the Bexar County Jail and up to a $2,000 fine. Did you understand?
Yes.
If you have a plea with the state, the court does not have to follow that plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Do you understand?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, she has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, I do.
Ms. Pettis, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and reentry. Do you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, the state is proceeding on the lesser included offense of a Class B theft. Punishment is assessed at 6 months in the Bexar County Jail. There's a $750 fine, and the state is recommending community supervision. Did you understand? Did you understand?
Yes, ma'am. Oh, yes, ma'am.
Yeah, I know. Did you understand?
Wait to that. You hear what I'm saying?
Did you understand? All right, excuse me, Miss Green.
Yes, I'm here.
Could you ask Mr. Behrens or whoever that is to maybe take that into the next room?
Okay.
Thank you.
Thank you.
You're welcome. Did you understand with a theft conviction that that's a crime of moral turpitude? Do you understand that and what that means?
Yes, ma'am.
All right. Ms. Green, did you understand that to be the plea?
I did, Your Honor. However, we would ask if the court would reconsider maybe probating half of the fine.
All right. State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years. There be 80 hours of community service restitution, no contact with Target at 8234 Agora Parkway, MRT, random UAs, obtain your GED or complete an anti-theft course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
Any objections?
No objections.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
And state your excuse. Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find that there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, just that you would follow the plea bargain.
Um,
All right, so why are you stealing?
So I had got sick, and none of the hospitals over there that I was at, they didn't take my insurance. And the sickness that I have, it's PIA. I don't want to say what I had. But I was getting like a real bad rash like on my body, and I had no money. I didn't know what I was to do at the time. I didn't mean to steal. I just didn't know what to do.
Go to the emergency room. So do you have any children?
No.
When's the last time you had employment?
Employment. I'm working right now
Doing what?
at Wendy's.
All right. And do you live with anyone?
I live with my boyfriend's aunt at the moment.
And are there any children in the household? And does your boyfriend stay there too?
Yes.
All right, so your attorney didn't have you sign the trial court certification of defendant's rights to appeal, so I'll go over that with you once we complete this plea, okay?
Okay.
All right, the court is going to sentence you to 6 months in the Bexar County Jail. That will be suspended and probated for 1 year. $750 fine. That will be probated. How far did you go in school?
I only made it to the 10th grade.
Why?
I dropped out for a dumb reason.
Why?
For a boy.
See, here's the thing. Don't go following somebody around. You need to focus on yourself and make sure that you're independent. You understand?
Yes, ma'am.
There's going to be regular reporting by Zoom or in person, regular random UAs. If you're drug tested today, what are the results going to be?
Honestly, I only smoked marijuana once, but that's it. I'm just
Okay,
gonna be
come on.
honest.
It's more than just once.
No, it was just once. I just messed up. Like I learned
When?
last week. Like I messed up.
So in all of your life, the first time you ever smoked marijuana was last week.
Yes.
Is that what you're telling me?
Yes, ma'am.
Okay, so I'm going to tell you right now, you need to be honest with me, because otherwise I'm going to send you off into this world. And if you end up testing positive again, a motion to revoke is going to be filed. Do you understand?
Yes, Your Honor.
All right, there's going to be regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be no contact with Target, so you're going to have to go to someplace other than Target.
Yes, Your Honor.
There's going to be 80 hours of community service restitution. You're either going to obtain your GED or enter some type of trade school. Do you understand?
Yes, Your Honor.
And once she's completed one of those things, then the community service hours will be deemed satisfied. And she's to do the anti-theft course. Usually I give people a theft course, but this is not your first time, so you need more help, okay? There's going to be field visits 1 time per month for 3 months. And why are you not living with your mom or your dad?
My dad right now, he's currently in prison, and my mom, she's out doing her own thing at the moment.
All right, you're going to have to really learn to support yourself and do what you need to do in order to get there, because if you don't, at any time where you're living, the aunt could get tired of you, tired of your boyfriend, and just say, you all have to go. And then you'll be homeless. Or either you and your boyfriend break up and they say you have to go, and then you'll be homeless. So start saving your money, all right?
Yes, Your Honor.
Probation, is there anything else she needs? All right, so this is what's called the trial court certification of the defendant's rights to appeal. Did your attorney review that with you? All right, so let me explain this to you. So what this tells you is whether or not you can appeal, like whether or not you can complain about your sentence. That's what it means in layman's terms. So you reached an agreement with the state. I followed that agreement. And because I followed that agreement, you're not going to be allowed to appeal, which means you won't be able to say, you know what? I think I should appeal that, right?
Yeah.
Because I followed your agreement. Now, what I can tell you is if there were pretrial motions that I heard, and if I made a ruling on that, you could appeal that. But your attorney has already said I didn't make any of those rulings. So you're not going to be allowed to appeal. Do you understand?
Yes.
And this is a conviction. Now, this is not a felony conviction. It's a misdemeanor conviction. But because this is a crime of moral turpitude, what that means, any job that you seek that requires you to have a license, this is going to come up on your record. Do you understand? Do you have any questions about anything?
So for the probation, they're gonna give me all like the paperwork and everything.
Yes, before you leave here today, probation will speak with you.
Yes.
All right, so do you understand the trial court certification?
Yes, Your Honor.
All right, then I'll need you to sign this. If you go to the side, they'll help you sign it, all right?
Okay.
Oh, they'll give you a pen. And Ms. Pettis, if there's any issues with you, just let probation know. And if so probation is not addressing it, you can always come back to the court. All right.
And now, my creatures of the night. It is time to unleash the worst production audio on the planet. It is time to go to where the souls of the damned are condemned, where the rulings are final, and the punishments are forever. Welcome, my children, to Dungeon Court.
January 30th, 26, 90 days with costs. No further problems. The case will be dismissed, and Mr. Caldwell doesn't have to appear if he's already paid the cost by that day.
If you can pay this before, then you don't have to come back. Okay. All right. It'll be about $150 thereabouts. Somewhere between 150 and 200. Okay. They'll have to give you the specifics of the window. Thank you.
State of Ohio versus Emily Justice, case number CRB 25-529.
And we have a co-defendant on this. I believe she's represented by Mr. Morford. Also Justice, but I can't recall the first name off the top of my head. I apologize.
Personally, Justice 25-529 is Mr. Shires.
State of Ohio versus Crystal Justice, case number CRB 25-528.
Your Honor, I've just received some video that's alleged to be of the incident that I need to review myself as well. The state is looking for some information regarding possible restitution that they don't have yet, so I think we need to come back on this one another time. A couple weeks would probably be good enough. I don't know what kind of time frame the courts want to set things at the moment.
14th's not a bad day if you want to use that. You're available, Mr. Morford?
Yes, Judge.
Okay.
I am as well.
November 14th will be the next hearing, pre-trial, 10 o'clock.
You said 10 o'clock, Your Honor?
10 o'clock, yes.
Thank you, Judge.
You're welcome.
State of Ohio versus Richard Riggle, Case number CRB 25668.
This is Mr. Stiers' case.
Thank you. And Mr. Regal is at Hometown Recovery, and we've got a report here for him.
Okay, looks like it's a good start, but we're just getting started, so.
Right, we just got Mr. Regal in to treatment a little less than a week ago at this point, so we're really just kind of getting right off on the right foot, but just also still getting started. So I don't know what kind of a time frame the court would like to look at coming back on this one. We would waive time constraints to accommodate.
3 to 4 weeks. Okay.
Courtroom was up there on the street just a minute ago.
Okay, let's go on to the hearings here till they appear.
State of Ohio versus Aaron K. Wells, case CRB 25558.
Mr. McCown's case set for pre-trial today.
Good morning, Your Honor.
Good morning.
Your Honor, it's my understanding we're going to ask for a continuance until November 21st. We will waive all time constraints. It's my understanding that the state is, I believe of the mind they're going to dismiss it, but because there's an alleged victim, they want to give her the opportunity to appear and state her position to the court. It may be different from theirs.
Okay, so you said November 21st?
Yes, Your Honor.
Mr. Hill, do you agree?
I do agree. We do want to give the alleged victim an opportunity to come and state her feelings about this. This occurred in the context of an exchange of the child for visitation, and sometimes tempers get the best of people. But in this case, I think this is something that they need to be able to work through themselves.
Okay, I'll continue the matter until November 21st for another pre-trial at 10 o'clock.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Devin Stevens, case number PRC 252546, ABC and D.
Yes, Your Honor. I filed my notice of appearance today as well as other documents. This is one we would waive time. We would ask that both of these cases be continued to November 21st. And the purpose of that, Mr. Hill has offered a potential plea agreement that would resolve the felony up here. We don't have discovery yet, so I think I need that to properly advise
That can be produced before the 21st date.
I believe it can be, Your Honor, not just for the record, so that everyone understands what our position is. Our intention is to, unless there is evidence mitigating against this, our intention is to take this on to the grand jury. However, Mr. McCown, as he always is, was very convincing in convincing me that we could look at the evidence here before we send it to the grand jury, and if we find that there's a good reason to leave it here, we will.
Okay, so there's waiver of time constraints until November 21st. Will be set for pretrial and preliminary hearing that day.
That's correct, Your Honor. Thank you.
You're welcome.
State of Ohio versus Gates County, case number CRB 25204.
And Mr. McDonald is representing Mr. Townsend set for a pretrial today.
Yes, Your Honor. I believe the state is in agreement that we are going to dismiss these charges. Mr. Townsend's been ongoing with couples counseling, and his counselor has written him a letter which suggests that she thinks that they've ran their course and they're ready to be released.
Mr. Hugh.
I did receive a copy of that letter from Mr. McDonald. In fact, I can forward this to Your Honor if you want me to. It does indicate that they've been actively engaged in the counseling. Gage and Erica both have demonstrated receptiveness to therapy, and I feel that they will reach out for help in the future if needed. Both remain very family-focused and invested in their children. So that was the goal of getting them to go to the counseling. Is Erica Townsend here?
No, our daughter broke her arm and she's getting her cast off this morning.
So Ms. Townsend originally, back in June, wanted us to drop the charges even then, but she agreed to go to the counseling. So if Mr. Townsend was able to pay the court costs today, we would be willing to dismiss the charges.
We're accepting of that, Your Honor.
All right, case will be nollied upon payment of court costs, and you can do that today. See the clerk, pay the costs, case is dismissed.
Thank you very much, Your Honor.
You're welcome.
State of Ohio versus Andrew Curry, the Lawrence County Jail. Jesse Friend is on deck.
All right. I believe this is Myers case.
Not aware of an active case. Is it post-conviction matter?
Well, could be.
Probation violation.
Oh, probation violation, okay.
Yeah, there was a complaint for probation violation filed recently. Have you had a chance to talk?
I wasn't even aware that he was involved in this. I don't know the nature. I could take a look at it and have it recalled, Your Honor?
Yes, I'll give you the files. Mr. Curry, Mr. Stiers is going to call down, talk with you, then after that's occurred, we'll have you back on teleconference and decide how we're going to go forward.
State of Ohio versus Jesse Lee Friend, case number CRA 25355. Spencer Lloyd is on deck.
Your Honor, Mr. Friend was previously at Bethesda, and he left ASA. I believe we had him forward through common pleas as well as parole and maybe even this court.
Yeah, in this court, he has a extradition matter pending to Mason County, West Virginia, and he had posted a bond on that. He had a hearing set October 17th in this court on the extradition, did not appear, and also he had left treatment without court permission. So a warrant was issued, and it's my understanding he was apprehended by Mr. Sowers and brought to the jail. So, and I have a note saying that Mason County, West Virginia still wants him, so that warrant in West Virginia remains active. So, I will revoke his previous bond on this matter. Well, we're going to need Mr. Smith as his attorney. Is he going to be here today? I'm going to revoke his bond and change it to $100,000 cash or surety.
He is here. Yeah, I am here. I drove all night to be here.
I got so upset after that game, I got in the car and drove back.
Well, when I went to bed, they were ahead, and then I woke up this morning. What happened? Went really far south from second half, it looks like.
Who is this film?
This is Jesse Lee Friend.
Oh, yeah, yes.
He's got a Mason County warrant, and he's also got some matters in our common police court.
In front of Judge Ballard, correct. He took it off the active docket, and he also issued a bench warrant, Judge Capper.
Okay, I'm changing this bond here to $100,000 cash or surety. It's my understanding I've been given the information Mason County still wants him, so I don't know how that's going to be balanced out. But I guess we'll let Judge Ballard make that decision if he's going to keep him or if he'll let him go back to Mason County. I understand the charges there are fairly serious.
I think he's going to keep him.
Okay.
But, yeah.
Well, do you have an idea when he's going to appear in common pleas?
I told Judge went to the inactive docket because he didn't show up, so.
So he hadn't been there yet?
No, he hasn't been there yet, to my knowledge.
I'm going to suggest we go out about a month and come back maybe a little before.
Sure, yeah. I'm sure it's going to get on the docket very quickly.
About the end of November, what's your schedule like?
I can do the very end of November, like.
24th or, I'm actually going to set a few cases. We'll have court on Wednesday the 26th, if you want to try that, or the 24th is tomorrow.
I could do the 26th. I know for sure without checking my calendar, I have nothing then.
All right, I'll set it for November 26th for pretrial new bond, $100,000 cash or surety.
Thank you, Judge.
100.
State of Ohio versus Spencer Lloyd, case number TRT 251332 A to B. Frederick Sloan is on deck.
$100,000 or your immortal soul, apparently. We're hanging out in Dungeon Court. It's our guilty little pleasure here on a Friday, especially on Halloween. So maybe a few extra minutes of Dungeon Court just for your, the torture on your ears. But it's the most unique courtroom in the world. I grant you that. There is no place more unusual than this. So let's get back to Dungeon Court.
Sir, you Spencer Lloyd? Can you hear me, Mr. Lloyd?
Yes.
Okay, and you are Spencer Lloyd?
Yes.
It's alleged that you missed a pretrial back in September the 12th. You missed the pretrial and a warrant got issued.
Your Honor, this is the case of that lawyer from Dayton.
Oh, okay, so now, all right, you have a felony that went on to the grand jury. The case here is going to go to the grand jury, so there's a whole program, I'm assuming, from
yes.
They're going to put, they set a bond, right? His lawyer says he's going to post.
Yes, Your Honor.
Okay, your lawyer was here today. Deal with them to these felony. We're getting a lot of background noise. I don't know where that's coming from. So, your case here is going to go to the common pleas. Your lawyer says you're posting the bond on that, so if that's correct, then you should be getting out on the bond from common pleas court. The case here is dismissed. Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus Freddie Sloan, case number CRA 25710, CRB 23777, CRB 181253. Brianna Maynard is on deck.
All right, and ma'am, you are Freddie Sloan.
Yes, sir.
Ms. Sloan, you have a right to remain silent. You don't have to say anything. You have a right to have an attorney, to have one appointed, if you can afford one. A right to bail and to make the state prove the charge against you beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You've got a new charge, and it's possession of cocaine is the charge. It's case number 25710. States alleging that on October 29th in Fayette Township, you knowingly obtained, possessed, or used cocaine. That's a felony of the 5th degree. Maximum penalty is a year in jail, $2,500 fine. Do you understand that charge?
Yes, sir.
Okay, then a copy of that charge was faxed to the jail, so I don't know if you have it yet, but it should be there for you to get. There's an old charge I don't think you ever got arraigned on, so I'm going to go ahead and arraign you on it now. I don't know how long it'll go forward. It's a domestic violence charge from 2023. Case number is 23777. And it alleges that at Fayette Township on December the 17th of 2023, you knowingly caused or tried to cause physical harm to Amber Sloan, and that Amber is a member of your family or household. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Now, since is this Amber that's here today?
Yes, Your Honor. And if you want us to tell you what we're thinking on that.
Well, I just need to know if you're going to go forward with that charge.
She doesn't want to go forward with that charge. So it's been 2 years. So
You're not aware.
we're not.
Okay, so, Ms. Sloan, you don't have to worry about the domestic violence. It's getting dismissed. Amber is here. She's asked the prosecutor to dismiss it since it's 2 years old. We're going to do that. Then you've got another old case, 18-1253 was a theft offense, and you got convicted on it some time ago, and you had a review hearing March 20th of 23 that you failed to appear for and got a warrant outstanding. So that's still pending because it's showing that you did pay something on your fine, but you never finished paying. You still owe $100 and you owe 5 days of community service. So, do you understand the charges against you?
Yes, sir.
Do you have the money to hire a lawyer?
No, sir.
And Mr. Morford, I'll appoint you to represent Ms. Sloan. She has a new possession of cocaine charge, and she's got an old Walmart theft offense that she never finished what she was ordered to do. That's the matters pending. What's the state's position on bond for Ms. Sloan?
Your Honor, I guess the only condition that we would, under which we would want her to be released from jail without a bond or with an OR bond at this point would be is if she would agree to go to treatment, be assessed for treatment, first of all. And if she would be accepted into a program, we would be agreeable to an OR bond.
So, I don't know if you, could you understand or hear that, Ms. Sloan?
No, I'm sorry.
Prosecutor said he would agree to you getting released from jail on a signature bond, which means you don't have to have any cash to secure your appearance, if he would agree to go to treatment. If you won't agree to go to treatment, then they want a cash or surety bond to secure your appearance.
I agree to do that.
Okay, what's your pay source?
I'm sorry, what?
How do you pay for medical treatment? Do you have a medical card?
Yes, sir.
Ohio? You have an Ohio Medicaid card?
Yes, sir.
Okay. Hometown is going to call and assess you, and I'm going to go ahead and do an order for her to be released to hometown for treatment with a $2,000 OR bond. Set, probably come back in a couple of weeks.
Please, Judge.
So that's going to be the 14th. Are you available the 14th?
Yes, Your Honor.
All right, we'll see you in a couple of weeks for a follow-up. So you're going to go to treatment. They're going to give you a report as to how you're doing. You've got to do what they tell you to do, how they tell you to do it, unless it's illegal or immoral. You don't have to do it. But otherwise, I expect you to do what they tell you. And follow and get a good report, because you're charged with a felony. So I know this is a lot, but I'll try to distill it down to a small amount of information. Felonies mean you can go to the grand jury. You have to go to the grand jury for an indictment. They're so serious, you got to be indicted by a grand jury first. Secondly, you can go to prison. That's the difference between felonies and misdemeanors. A felony, you can go to the prison, not to the local jail. So if you mess this up, you could get sent to prison. And it won't be me sending you, because you won't stay here in this court. You'll go to the main courthouse in Ironton, and one of the common police judges has the authority to send you on to prison. That's not a good option. That's not what you want to do.
No, it's not.
So, win-win, get clean, take advantage of this opportunity, and don't have a felony on your record, because if you're successful, complete treatment, I believe the prosecutor probably would agree to dismiss your charge on the road. That's not going to be like in 2 weeks or 2 months. Probably a year from now, if you're successful, then they may dismiss your case. So you got to really do this. Not just fake like you're going to do it. To get it dismissed, you got to really do it and get clean.
Yes, sir.
Okay, is that what you want to do? Yes?
And I'll leave it from here to treatment?
Yeah, you're going from the jail to treatment.
Okay.
And the other options aren't very good. You can stay in jail and get sent to the grand jury and get indicted, and then go face one of the common police judges and try to convince them of what you want to happen. The best thing you can do, I think, logically, take advantage of this treatment. If you had to pay for it yourself, it's thousands of dollars. And tell you the truth, I don't know how much longer it's going to be available. I mean, you're getting right in on the tail end of it. It's probably, a lot of it's going to go away here pretty quickly. So take advantage of it, get clean. Sure your family are still here.
I am.
Do I get an amen from you?
Amen. And Butch, thank you so much.
So we got your family, I assume your family,
Mom and sister.
mom and sister. They're amen on what I'm saying, so they want you to do it. Mr. Morford wants you to do it. I don't want you to do it. But you know who's most important? Do you want to do it? Do you want to do it? And here's the other thing I said at Chesapeake High School, and it applies to adults too, but especially applies to kids. Who you hang out with is so important. If you're hanging out with people using drugs, guess what? You're going to use drugs. So you may have to make some changes. If you want to change your life, you can't say, well, I'm going to get clean and then go pal around and hang out and run around with people that are using drugs. It's not going to work. Okay? Well, I don't know that. I'm just going from past experience. And if you've got a boyfriend that's using drugs, you're not going to quit using drugs. Or if you're a male and you got a girlfriend and you try to get clean and you got a girlfriend that's using drugs, guess what? You're going to keep using drugs eventually. So, you got to make some changes. Make some changes. It's time. How old are you now, Freddie? I've had you for a while. 46. Okay, you're a full-grown woman, even today's day. 50 years ago, that was an old woman. Now, when you're 30, they act like you're 13. So 46 is a way full-grown woman. It's time to straighten out and do what you need to do for your family's sake. Amen? I need an amen over here. Okay. I'll see you on November the 14th, hopefully with a good report.
Thank you.
You're welcome.
Thank you.
You're welcome.
Thank you, Your Honor. Thank you.
State of Ohio versus Brianna Maynard, case number CRB 25548. And Edward Markle, Emery Markle, is on that. Brianna Maynard.
All right, this is Mr. Steyer's case. It's set for a pretrial today.
Your Honor, Ms. Maynard is, she has a misdemeanor case pending here. It's my understanding that she is due to be sentenced sometime in the next week or so in College Police Court to prison time. This is a case, I think the victim wasn't all that interested in pursuing domestic violence. The state has indicated that since she's going to be in jail anyway because of the matter of common pleas, they'd like to continue this out past her sentencing, and the intent is probably not at that point. Okay. When do you go back for common pleas, man?
What is that, sorry?
When do you go back to common pleas court?
I already took a deal, so I'm just waiting on sentencing.
Wednesday. Wednesday.
Probably Wednesday.
Okay, if we can come back fairly soon after that, because we'll haul her up and get the transported once she's sentenced.
Okay, so that's, we can do it the 7th if you're available then. November 7th.
All right, let's set it down.
All right, Dan, I'm setting your next hearing for a week from today, November 7th.
Okay, thank you.
Pretty strong.
State of Ohio versus Emery Markle, case number TRD 22-2694 A and B, TRD 2938. Andrew Curry will be on deck.
Are you Emery Markle?
Yes, sir.
It's alleged that you missed a hearing June the 5th of 23 on a no operator's license and a theft offense. And the warrant's been outstanding since then. It looks like you got nabbed on the warrant.
Yes, sir.
You admit or deny you failed to appear for your review hearings before?
Yes, sir, I did.
Yeah.
I paid $100 yesterday on these lines.
That's correct, you did, I see it. Is there anything you want to tell me about this, why you didn't appear? Or?
I just moved out of town. I just moved back like this week, really.
Well, welcome back.
Yeah, thank you.
You get a welcome back warrant.
Yes, sir.
Well, these are, I'll tell you a little secret, I don't know if most people know. When a misdemeanor warrant, if you'll move away from the state and stay away, we won't come get you on a misdemeanor. But you're fair game as soon as you come back on a misdemeanor in the whole state. I mean, you could go to Cleveland and still get nabbed on a misdemeanor warrant. So,
yeah,
you came back. So,
yes, sir.
Where were you living before?
In Kentucky.
Oh, not that far away then.
No.
Well, do you want me just to change this all into jail time, or do you want to tell me that you're going to take care of it?
I'll take care of it.
Okay, you did pay $100, so that's a start on it. Let me see what you still have. You've got 18 hours of community service on the driving under suspension and $510 in fines and court costs, and there's a warrant fee. But whenever a warrant's issued, clerks have to type it out, send it to the sheriff. Sheriff's got to put it out there for everybody. So there's some work involved.
Yes, sir.
So we charge a fee for that, and then you still have, looks like probably $300 and some owed on the theft offense and 5 days of community service. So where are you living now, Mr. Markle?
Back in Iron now.
What's the address?
75 Private Drive, 1176.
Ironton?
Yes, sir.
Okay, I'll send you the time served for missing your hearing. Give you another hearing date, and this will happen again if you don't show up.
Yes, sir.
Or just take care of it, and then you can quit coming to the review hearings.
Okay.
Let's see, I need to get you a date. I'm going to make it December 1st. December 1st, that's a Monday, 9 o'clock. You know where
Yes, sir.
You know where the court is in Chesapeake?
Yes, sir.
Okay, that's where you gotta be, December 1st, 9 o'clock, or finish everything you were supposed to do. If you get it all finished, you don't have to be here. You don't have to finish, you gotta show up, or you'll get another warrant.
Okay.
Okay, that's all.
It's a supersized edition of Dungeon Court. Why not? Because it's Halloween. We'll hang with it a few more minutes, and then we will call it a day and a week. And yeah, and then we'll send you out onto your merry way. We'll release your souls from the corruption of Dungeon Court.
Look at the complaint from probation officer is based on his being asked to leave hometown recovery. I would assume then that the court would probably like to see him get back into a program. Hometown is only recommendation. That's what my understanding is that TCC might be willing to look at him.
Mr. Tarvin? All right, Mr. Tarvin's gonna call down and talk to Mr. Curry, and you'll let us know how you want to proceed. Okay, we'll recall later in the doc.
State of Ohio versus Billy Finley, here at the court, case number CRB 21-197.
I can explain what this is, Your Honor.
Okay, I've got a motion for Nolly.
Yes, and I just want to make sure that he has 3 charges pending, or at least 3, if not 4, charges pending before the court, and the only one that And the reason that he wants it nollied, and it's the criminal trespass charge, is because Mr. Finley is going to be locked up in Kentucky for a while. And I've confirmed that. He says he's going to be in prison till 2035, but I see on here he's eligible for parole in 2026, so he may be getting out. So as far as the criminal trespass charge, we're okay with going ahead and nollying it, but there's also an OVI, a failure to control, and a felony theft charge that are still pending, and we want those to stay in place with the warrant.
I don't have those files, they must be on the docket for a different day.
Well, I don't know if they're on the docket at all, because I think he failed to appear in the past.
Oh, maybe he already has a warrant then.
Yeah.
Okay. Well, for 21-197, I'll go ahead, I'll sign the entry nominee, so it'll be nominated.
State of Ohio versus Deshaun Caldwell here at the court, case number 085-464.
Mr. Stiers' case set for pre-trial.
Carl Cottle here.
Suspended, and in order to stay away from him, if you want to be discovered, I can look at the discovery or whatever, basically, you'd be on probation for 2 years, in order to stay away from him. Judge might put a fine on your legal costs. You don't get costs on your problems. We'll do that. Your Honor, I think we have an agreed to disposition on this case. State has offered that in exchange for a guilty plea to the assault charge, they would agree to a recommendation of 30 days in jail suspended, 2 years probation, and in order to stay away from the alleged victim. We would join in that recommendation, and pursuant to that, we'd enter a guilty plea at this time.
All right, it is Caldwell, right? Is that the
Yes,
last name?
the defendant is Mr. Caldwell.
All right. Mr. Caldwell, do you agree with what your attorney has stated to the court?
Yes, sir.
Okay, both of you have the right to make a statement. You don't have to. Do you have any statement you want to make to the court? No, see you shaking your head. All right, Mr. Hill, do you agree with what's being recommended?
Yes, Your Honor.
All right, I'll impose a $100 fine, court costs. And was it 30 days in jail suspended?
30 days suspended, Your Honor.
30 days in jail suspended, order to stay away from the complaining party, Carl Cottle.
Yes.
Caudill.
Yes.
And they don't live together or anything like that, so it's not a problem.
No,
that
no.
way.
No, it's
2 years of level 4 probation. Review hearing on May the 8th of next year. Please see Mr. Major in probation office. For review hearing on May 8th, 9 o'clock next year. Go see Mr. Major in pre-go.
Yes. And he did not leave. You got a copy of this. 1031. So that's your review here today. You step out here and talk to the probation officer.
State of Ohio versus Antonio Caldwell, case number CRC 25603.
This is Mr. Stiers' case.
They're offering to come back in 90 days. There's no further problem. You'll go back to the apartment complex and pay the court cost of dismiss the charge. You agree with that? Okay. Your Honor, this matter is a criminal trespass. The state has offered that if we do a 90-day continuance, have no further problem, Mr. Caldwell doesn't return to the complaining property, that upon payment of court costs, they would be agreeable to dismiss the charge. And we're agreeable to that. We would lay time constraints to accomplish it. 90 days out is about end of January.
Yes.
So January 30th is almost exactly right, and I'm available that day.
I'll set it for January 30th, 26, 90 days with costs. No further problems. Case will be dismissed, and Mr. Caldwell doesn't have to appear because he's already paid the cost by that.
You can pay this before, then you don't have to come back. Okay. All right. How much is it? It'll be about $150, thereabouts, somewhere between 150 and 200. Okay. They'll have to give you the specifics of the window. Thank you.
State of Ohio versus Emily Justice, case number CRB 25-529.
And we have a co-defendant on this. I believe she's represented by Mr. Morford. Also Justice, but I can't recall the first name off the top of my head. I apologize.
Emily Justice, 25-529, this is Mr. Steyer's case.
State of Ohio versus Crystal Justice, case number CRB 25-528.
Your Honor, I've just received some video that's alleged to be of the incident that I need to review myself as well. The state is looking for some information regarding possible restitution that they don't have yet, so I think we need to come back on this one another time. A couple weeks would probably be good enough. I don't know what kind of time frame the courts want to set things at the moment.
14's not a bad date if you want to use that. You're available, Mr. Morford?
Yes, Judge.
Okay.
I am as well.
November 14th will be the next hearing, pre-trial, 10 o'clock.
You said 10 o'clock, Your Honor?
10 o'clock, yes. Thank you.
Thank you, Judge.
You're welcome.
State of Ohio versus Richard Riggle, case number CRB 25-668.
This is Mr. Steyer's case.
Thank you. And Mr. Regal is at Hometown Recovery, and we've got a report here for him.
Okay, it looks like it's a good start, but we're just getting started, so.
Right, we just got Mr. Regal in to treatment a little less than a week ago at this point, so we're really just kind of getting right off on the right foot, but just also still getting started. So I don't know what kind of a time frame the court would like to look at coming back on this one. We would waive time constraints to accommodate.
3 to 4 weeks, 21st or after November.
Well, Your Honor, apparently Mr. Regal already has a court date on the 7th on another matter. Might be worth setting them together at this point at least, and then maybe from there decide what we want to do in terms of going, whether to separate them out or not.
November 7th will be the next hearing, 10 o'clock.
Who's your attorney on that? Okay. Okay. So yeah, we could just set that together at this point, then we'll go from there.
All right, November 7th.
Thank you.
Thank you, Your Honor.
Thank you.
State of Ohio versus Shannon Eastep, case number CRA 25-606.
May I approach, Your Honor?
Yes.
Right, copies regarding
Are these copies for?
Are those?
If you need, you can have them,
We can
or
make
I just,
copies.
okay, yeah, that would be great.
We'll get you copies back.
Okay, thank you.
Well, she's at Huntington Treatment Center, which is not, I'm not a fan of. So I don't know how the state wants to proceed. My problem with the methadone, two things. One, they give people whatever they want. If you keep asking for more, they'll just give it to you. Two, I see so many people that are doing methadone, and they do other drugs on top of the methadone. So it doesn't seem to really curtail their urges for other use of other drugs. So I'm not a fan of methadone clinics.
Your Honor, I believe that OVP is one of the providers that can work with people who are also taking methadone, maybe helping them to come off of the methadone.
There's no one here from them today, but that is my memory as well, that we've had people that have been on methadone that are also able to seek treatment through OVP. So I'd like to maybe kick this out a couple of weeks, when I come back on the 14th, and ask her to speak to OVP and see if we can work out at least some parallel treatment.
Okay.
Is the 14th a good date, Your Honor?
That's fine. November 14 will be the next hearing.
I'll get you those copies and come talk to you. Don't leave till I talk to you. I got enough more cases to get going right now.
Okay, I want Mr. Cooper to copy the documents.
Yes. I've asked her to stick around. I'm going to speak to her after my case are called as well, to help her get in touch with OVP.
Thank you, Judge.
You're welcome.
All right, my little ghosts, goblins, ghouls, ghasts, and gremlins. That should put a wrap on it for a Friday, for a Halloween. Thank you guys so much for joining me again today. It's been a fun week here, guest hosting. Once again, Michael Groff filling in for Mr. Dan Soul, who is on a vacation. And of course, I want to wish him and his family safe travels, and his daughter, congratulations, getting married this weekend. So that's wonderful. And he'll be back on this channel, not in this seat, but on this channel on November 10th. So you've got me for yet another week, and that'll be 5 more shows, Monday through Friday, 10 a.m. East, 7 a.m. Pacific time, right here. If you're in Arizona, keep in mind the time change happens this weekend, which means we don't change our clocks here in Arizona, but that means this show, if you live in Arizona, starts an hour later. So do keep that in mind. Plus, we have Sidebar next week as well, so remember that. A couple other things real quick. Happy birthday once again to my OAO and the executive producer for this program, and that is my Michelle. So thank you so much. Be sure to check out my channel, Michael Groff. I've got a number of channels, but one I do is the Phoenix, Arizona weather discussion. Do check that out. Really would appreciate that. And other than that, I think we've pretty much covered everything. Thanks to Barbara, Ashley, Mama Joan, Lindsay, Wahoo, everybody that has donated and helped us out this week. Get channel memberships gifted, super chats, super stickers, all of that helps out the channel as well. Dan appreciates that. I appreciate that as the guest host as well. So once again, thank you so very much for that. We'll see you back here Monday morning, 10 a.m. East, 7 a.m. Pacific, for another exciting TCF Live. So thank you once again. Have a great weekend, everybody. Goodbye now.